I have an ailing father who is suffering from terminal diseases. So this is the condition. From 10th evening, my lord, there is no electricity. And this is in Dover Lane, Calcutta, my lord. Kindly consider. In this place, my lord, I have made
Why it has been disconnected?
My lord, my all bills have been paid. There is a landlord-tenant dispute. That is the reason. So landlord-tenant dispute, your lordship knows, my lord, landlord cannot cut off my electricity, my lord. So my lord, this person is about to die, my lord. That is why, my lord, I come on this Friday. But I intend to move it at 3 p.m. today, my lord, because
Today it is not possible.
or at the very, because I'll tell you, lordship, is this person's health is really very bad, my lord. He is terminally ill. But he's discharged 1 week back, my lord.
Allowed to affirm the affidavit and list on Monday as urgent motion.
Yes, Monday, my lord. Well, kindly at the top of the list.
Urgent motion.
Yes. Wait.
Very interesting point of law has been pending for some time.
42.
167.5.
Huh?
167.5 series.
Okay.
Repeated.
1697.
This is the point of law. My lord, it will not take very long. I've spoken to my other side. Just today, my lord, I will do it. In case
I don't think it will reach today.
But can it be 14th January?
14th
I
January.
have taken consent of Mr. Abhishek sir.
We got an order. 14th January, see, at 2 p.m. is any fixed? Pena. Item number 42, CRR 1697 of 2012. As per the submission made by the counsel for the petitioner, let the matter appear on 14th January 2026 at 2 p.m. As a specially fixed matter. Police the petition director to inform the date to the London Council appearing for the
Kind leave to mention, my lord, group 9 matter, my lord. My lord, here the order matter will be renewable on 15th. However, my lord, 18th the order is expiring. Now, my lord, what happened is that, my lord, affidavits are not yet completed, my lord. I am for the petitioner, my lord.
Yes.
The respondents have not yet filed their affidavits, except one respondent, my lord, have not yet. My lord, kindly, my lord, this matter appear on 15th as to be mentioned, so that, my lord, at least they'll complete the affidavits and the time can be extended, my lord. We can it, my lord, after this, my lord, and
It's already 15 December is fixed.
yes, my lord, kindly put in a to be mentioned, my lord.
Why?
My lord, affidavits be completed, they have not
No
completed.
affidavits out. Okay.
Not completed. That's the reason why I'm saying it, my lord.
15 December as to be mentioned.
Lordship, may I be permitted to seek leave to file this matter and move it urgently, my
What
lord?
is the urgency?
The urgency is that, my lord, in the month of March and May, the petitioner have purchased a substantial quantity of steel. My lord, after that, it was kept with the Kolkata Port Trust, now formerly known as Kolkata Port Trust. Now, after representation, several representation, they are not releasing our steel. So,
Why?
without
They
any...
are not paid. You are not paid the demurrage charges. It was lying in the port area.
Milord,
It is, I think, within there is some specific hours. After the hours, if you will not remove, then you have to pay the demurrage charges.
Milord, we are ready to pay, but after that, when a hearing was conducted by the estate officer of the concerned port, Milord, they actually they rejected our claim, Milord.
Why? What is the ground for rejection?
Milord, the
Payment of non-payment of charges or what? State officer.
estate, yes, Milord, estate officer.
The matter went to state officer.
Milord, it was for
Whether the material was unclaimed earlier.
Milord, representation were made to claim the articles, Milord.
Now what do you want?
Milord, I want release of the articles urgently, Milord.
Can you file? It will come on Tuesday.
Milord, kindly grants me a leave.
Leave granted to affirm the affidavit and to be listed as urgent motion on Tuesday.
Lordship, in this matter, your lordship, leave was granted on 10th December, lordship, to be listed on today. But lordship, I have some difficulty. I could not file this petition, lordship. This matter before the circuit was Monday circuit. this matter relating to before the circuit bench, Lordship.
Circuit bench of Jalpaiguri.
Jalpaiguri, Lordship. The Monday court will start, Lordship. I'm proof only minor correction of this leave, Lordship. It was listed to on today, Lordship. I have not filed. So,
It is
Lordship,
not yet a form. How it will?
no, Lordship, everything has been completed, only filing.
So what you want now?
I want, Lordship, minor correction, Lordship, this matter before the normal regular bench, before the circuit bench. I want to move this matter.
Before the regular
No,
bench.
Lordship, because, Lordship, affirmation has been completed here, Lordship. Without your leave, Lordship, I cannot file before the circuit bench because affirmation, everything is
You
completed.
filed it.
No, Lordship, Monday matter will be filed before the circuit bench, Lordship.
Circuit bench is from Monday onwards.
Yes, Lordship. Only minor correction will be before, at least before the regular bench for the circuit bench.
Unless and until it is not registered, listed before this court, how this court can pass an order?
No, Lordship, I'm not paying for order, only correction for leave. Like, without your Lordship leave, I cannot affirm this petition because circuit bench is not
So
available.
therefore, it is not yet affirmed.
No, Lordship, affirm has been completed.
So if it is affirmed,
Only
how it
number has not been given just because, Lordship, Monday, this court will be sitting on Monday, Lordship.
So go
I want to move this petition before the circuit bench on Monday.
go and move.
But Lordship, here is a mention the matter listed to be on today.
Leave is granted on up here. Urgent motion. So you are not filed.
No,
So it is
Lordship.
not listed.
Lordship.
So what do you want?
I want, Lordship, this matter moved before the circuit bench. Your Lordship, just only correction for
Madam,
listed before the circuit bench, normal regular bench, Lordship.
leave is granted to the petitioner to move before this.
May I be permitted to mention a matter, Your Lordship, for extension of interim order?
Date में कर दो. Leave granted to the petitioner to move before the regular circuit bench at Jalpaiguri.
Your Lordship, may I be permitted to mention a matter on urgent basis? The interim order is expiring tomorrow. I have mentioned the matter on Tuesday. Your Lordship has been pleased to direct the matter to be listed on 11th, but till today it has not
Why
been
it is not
listed.
listed to be mentioned? Interim order. List to
Lordship,
18. When? 18.
No, Your Lordship, tomorrow. It is
Tomorrow is
expiring
Saturday.
tomorrow. Yes,
Tomorrow is Saturday.
this is the last order, Your Lordship.
Why it is not listed as to be mentioned?
Your Lordship may kindly take it up today, Your Lordship. Yes, I have mentioned on Tuesday, Your Lordship. ফাইল এসে গেছে হ্যাঁ ফাইল এসে গেছে কোর্টে আছে ফাইল
Group 9 matter?
Yes, Your Lordship.
What is the matter?
This is a matter challenging an order of the
Pollution Control Board.
yes, Your Lordship. No, Your Lordship, the order I have challenging the order of the district magistrate Purbo Mednipur. I have filed this writ petition, Your Lordship.
Yes. Till 13th of December. Today?
12th of December, Your Lordship.
Who is the other side?
And they say for pollution control for Mrs. Papia Banerjee Bihani is appearing.
Supplementary में करो. Supplementary में for extension of interim.
Yes, sir.
Yes. 2 बजे रखो उसके साथ.
Grateful, Lordship.
I'm seeking your lordship's kind leave to mention
Your
item
Lordship,
number
can it be
500.
on 1 p.m. because I'm led by Mr. Shoptangshu Basu.
Extension of interim order. Why the substance and
Grateful,
senior advocates are bringing here?
grateful,
Take
Lordship.
for your lordship's kind leave to mention item number 551 of today's daily list. Lordship, the writ petition was filed last week. It's challenging an order passed by the State Consumer Redressal Commission, a sale before the NCTRC, your lordship, order passed without opposite quorum. So your lordship, it's vitiated by quorum non-judice. Your lordship, subsequently in the execution application, the petitioner's sole property in which he is residing, he's an octogenarian, he's terminally ill, is residing, that
So what
property,
you want?
your lordship, the property is being attached. Your lordship, I've received
Who
this,
attached?
your lordship, in the execution proceeding by the collector. Your lordship will kindly appreciate. Your lordship, we filed it last week. Your lordship, I'm only praying for upgradation so that it can be taken up sometime next week because this is my sole residing property, your lordship. I'm carrying the letter that I've received, your lordship, from the district
18th को
collector.
रखो उसको. Urgent motion.
Lordship, may I be permitted to mention for inclusion of a matter?
Tuesday now.
My lord,
Tuesday and Thursday.
my lord, may I kindly permitted to mention, my lord, regarding I have participated 4 tenders in
What is the urgency?
urgency is my technical bid rejected with extraneous clause which is not incorporated in the tender. That is 4 tenders about 4, and unauthorizedly with maliciously my tender has been rejected. Technical bid and not opening the financial. Others, they are opening the financial bid and proceed for the reverse auction, and soon they will award the contract.
When you file the writ application.
Today, just I will submit. My lord, give a fixed date.
403, my lord. Matter listed under heading new motion. Actually, it wrongly appeared. Matter will be listed as motion, my lord, as per order of the.
Okay, no problem. Motion, no motion, we'll see to. Yes.
My lord, leave maybe.
No problem. Motion, new motion, it will be when it will take.
My lord, leave may kindly be granted, my lord.
Your Lordship, this writ application has been filed against the order passed by learned NCDRC. Your Lordship, they have already filed the execution application. The next date is on the 17th, Your Lordship. On the last date, they have order has been passed of personal appearance of us, Your Lordship. The matter was
Personal appearance of?
Of us, judgment letter, Your Lordship.
Ah.
The last date this matter was appearing was in the.
Have you challenged that order?
Not yet, Your Lordship. The writ application.
Against which the execution proceeding is in.
No, we have challenged the order passed by learned NCDRC.
Ah.
Now, this matter was last appearing in the monthly list of September, Your Lordship. Thereafter, this matter is not appearing. Your Lordship, I'm praying this matter to be included.
When the matter is fixed for personal appearance?
17th, Your Lordship.
17.
Yes.
16 ko karo.
Brief, Your Lordship.
Urgent motion.
My lord, 1 second, my lord.
My lord, one matter, my lord. Item number 2. Item number today's list. Item number 540. I have challenged the proceedings.
What you want, you tell me.
Upgradation, my lord.
No. Yes.
My lord,
Correct. Yes, call that.
after filing of this writ petition, police authority threatening me to withdraw.
No problem. When the matter will take. Yes, call that.
My lord, leave may be granted to
Sorry.
fix the matter.
CRR is dismissed. Yes, next.
This is for extension of interim order. But this order is been expiring today, Lordship.
Who is for the other side?
My learned friend is appeared.
Number 4.
Well, I got the response of 1 and
Yes. Any objection? The matter is listed as to be mentioned for extension of interim order. Interim order is extended till 22nd of January 2026 or until further order, whichever is earlier. Let the matter, it is in the list. Matter in the list. And let the matter be placed in the list under the heading adjourned motion.
I'm deeply obliged.
Yes, next.
I'm for the application. It is an application for restoration.
Yes, give.
My lord, the case was filed in 19.
Give the file. Okay. Yes.
My lord, it is the final application for restoration of the work.
When?
This application for restoration along with section 5 application. My lord, the.
No, item number 3.
Yes, my lord.
It is a crane.
My lord.
Is the criminal revision application?
Yes.
What is the criminal revision? 1996. When it was dismissed.
No, the criminal revision application 1996.
Correct, that's what I'm telling. When it is dismissed?
My lord, dismiss on 19/11/2018.
2018.
Yes, my lord, 6 months, 6 years, 11 months delay.
Ah.
My lord, delay, what happened? My lord, the case was finally listed on 26/2/2002. And ready for hearing. Now, my lord, on 19/11/2018, none appears. But before that, my lord, the rule was issued, record was called for. But from 18 onwards, my lord, there was a non-appearance because the learned advocate, Mr. K.P. Hyde, he was appeared conducting the case. He expired and he did not appear, and ultimately case was dismissed. Then it was sent down. The lower court record was sent down. Then the notice was issued to appear to the accused petitioner. Then when he appeared on 18/12/2024, now it came from the record. The High Court case was dismissed, my lord. Then he came before the High Court and had that the learned advocate died long before that, and matter was not called. My lord, I was asking for sitting for restoration of the fees. This is the matter.
Where is the order? Dismissal
My lord,
order?
dismissal order is that.
Where is the order of dismissal?
My lord, at page 20.
Page
20.
Yes. What is the case?
Well, the case was section on IPC section 447 criminal trespass, and section 323 was that is voluntarily causing harm. Against that order, that was challenge.
Against the conviction?
Yes, my lord.
What is the conviction?
Conviction is, my lord, that 3 years and 500 is, and next is 1 year and 1,000 is.
Where is the order of the conviction?
Well, the order was passed in the order of conviction was passed. Well, it was in 15/5/1995.
So after that, what has happened before the trial court?
It appeared and next date is given for hearing.
They appeared and judge is given.
Therefore, after appearing, I came to know that case was.
What has happened? Why the court has not taken into custody after the conviction?
Well, that
Okay, I am calling the report. Why he has not been taken into custody? Who is the judge? There is a conviction. Magistrate has passed an order, then you have preferred an appeal. Appeal has been upheld, conviction has been upheld, and the matter has been dismissed by this court, and you went as a guest before the court, and court has given the date to you without taking into custody after the conviction. This is the way the trial court is working.
My lord, summon was issued.
How the summon can be issued? It has to warrant is to be issued.
My lord, this is.
Okay, I am passing an order. I will take your application. Let the surrender. And I will take your application.
Well, already he is appearing.
Correct. How they can appear? They have to be surrendered. And
this is the notice they are issued by the lower court below. As per this order, my lord, they appear. Then now next date is given, my lord, for next.
Sure. Let your magistrate should also face the consequence. Where is the order?
Well, order not. That is the summon issued from the court to appear in the court below.
How the assistant session which can issue the notes?
My lord, that assistant for detail of the case. For that is why the retrial was given from appeal court to retrial of the case, because the decision was converted to somewhat converted. Then it was sent down to assistant session judge.
And you are agreed with the appellate court's order?
Yes.
What is the ground for agreed?
My lord, that application I don't have not yet. Now I got the certified copy of entire thing after demise of advocate. Now I am appearing, my lord.
The petitioner has filed the present application being CRAN number 1 of 2025, praying for condoning the delay. I am praying. CRAN is condoning 1. CRAN 2 is which CRAN is delay?
Delay is 6 years, my lord.
Which application is condoning delay?
Next is, my lord, the condonation of delay is next one. 2. Application number 2. my lord.
Filed an application being CAN number 2 of 2025 for condoning the delay of 2,499 days for referring an application being CRAN 1 of 2025 for recalling of the order dated 19/11/2018 passed by this court in CRR 2872 of 1996, wherein the criminal revisional application was dismissed for default. For default. The how many petitioners? One petitioner. How many petitioners?
My lord, my petitioner is
Not knowing anything, they are referring to the High Court. How many petitioners?
4, my lord. 4.
The London Trial Court, that is the London Trial Court, that is Assistant Session Judge, Additional Court, HON'BLE, had convicted 3 of the petitioners, namely Parimal Biswas, Paritosh Biswas, Ganesh Biswas, and Kangali Biswas for the offense under section 447 of the IPC and sentenced to suffer a rigorous imprisonment for 3 months each and also to pay fine of ₹500 in default to further further RI of 3 months. The petitioner Kangali Biswas was further convicted for the offense under section 323 of the IPC and sentenced to suffer rigorous imprisonment for 1 year and also to pay fine of ₹1,000 in default further RI for 6 months. Full stop. Being aggrieved and dissatisfied with the judgment passed by the learned additional session judge dated 15th May 1995, comma, the petitioners have preferred an appeal before the learned judge special court within bracket EC Act, come as additional district and session judge HON'BLE, being criminal appeal number 39 of 1995. The learned appellate court by setting aside the judgment of conviction, remanded the matter back to the learned assistant session judge with the direction for delivery a fresh judgment after considering the materials on record. The learned appellate court has also given liberty to the learned assistant session judge to examine further witnesses if necessary. Being aggrieved and dissatisfied with the judgment passed by the appellate court in criminal appeal number 39 of 1995 dated 6th of July 1996, comma, the petitioners have preferred the present revisional application under section 482 of the Code of CRPC. This court finds that the criminal revision was filed in the 1996, and since then the matter was pending. The matter was taken up for hearing on 19th November 2018. On that day, none appears on behalf of either of the parties, within bracket, either appellant, either petitioners or the state. Accordingly, this court has dismissed the said revisional application for default. Thereafter, the petitioners have not taken any step for recalling of the order dated 19/11/2018. Now, after the period of more than 7 years, the petitioners have filed the present application for recalling of the order dated 19/11/2018. The learned counsel appearing for the petitioners submits that the petitioners were not aware with regard to the dismissal of the revisional application. The petitioners only came to know about the dismissal of the revisional application when the petitioners have received a notice from the learned trial court for appearance before the trial court on. When you receive the notice?
Notice date is not there, but he appeared on 18/12/2024, next date of appearance.
On August 2024. August 2024.
18/12/2004.
18th of December 2024. Immediately when the petitioners came to know, immediately after receipt of the summons, the petitioners have contacted the learned advocate, and the learned advocate has filed the present application for recalling of the order along with an application for controlling the date. This court finds that the case was initiated against the petitioners in the year 1990. year 19. No, in the year 1992. 1992. And the London trial judge has disposed of the said case in the year 1995 by convicting the petitioners for the offence 447 of the IPC and section 323 of the IPC. Subsequently, the appellate court has disposed of the matter in the year 1996. Being agreed with the appellate court order, the petitioners have preferred the present revisional application. This court finds that when the petitioners have filed the revisional application, have also is there any stay?
Yes, my lord, initially there was a stay when admitted.
Which date?
My lord, the date is on the date was admitted, that is on my lord, page 27.
The petition also got an order of stay of the order of conviction as well as order of the appellate court. The petitioners are enjoying the interim order and never made any endeavor to process the present revisional application. When this court has dismissed the revisional application, now after the period of 87 years, the petitioners have preferred the present application for recalling of the order with an application for condoning the delay. This court did not find any justification, did not find any sufficient reason, why the petitioners have come after the period of about 7 years for filing the application. Accordingly, this court did not find any reason to allow the condonation. The CRAN numbers 1, 2 of 2025 dismissed. Consequently, the CRAN number 1 of 2025 is also dismissed. The full stop. The London trial court is directed to expedite the trial and to dispose of the matter as early as possible. Yes, next.
Item number 4, my lord, I am for the petitioner, my lord.
Yes.
My lord. This is my 2 affidavit of service, my lord. One is for restoration application and another is for, my lord, the writ petition. And one envelope has been written in connection with the writ petition.
What is
My
that?
lord, the matter is dismissed for default. Can, my lord, for restoration application?
Which
My lord, on 19th of September, my lord.
can number?
Can 1, my lord.
Can 1. Where is the impugn order, the order which you want to recall?
My lord, that is the page 14, my lord.
None appears September. None appears on behalf of the other parties. Dismissed for default. 18 September.
Yes, my lord.
Yes.
18 September, and that was filed on
What is the
24th.
reason given?
My lord, actually on that day I have stated in paragraph number 3, my lord. Actually on that day, my lord, I was engaged in courtroom number 8, my lord. And matter was continuing, my lord, till 4 AM, my lord. For this reason, I was not able to, my lord, appear before this honorable court, my lord.
So this 18 September, the matter was dismissed. When you filed this application?
My lord, 24th, my lord.
24th of September. What is the matter about?
My lord, matter is related to the, my lord, in a BSNL mobile tower. My lord, the electricity connection was disconnected by the private respondents. My lord, the one is civil suit, eviction suit is pending, my lord. That is still continuing. And my lord, they are after, my lord, forcefully disconnect the electricity connection of that mobile tower. My lord, they are also not allowing the entering the BSNL personnel for maintenance work and, my lord, the other allied work, my lord. My lord, that I have stated also at, my lord, last annexure, page 32.
Have you served the notice?
Yes, my lord. Everybody was served.
Which is returned. To
My lord,
private
that is the respondent number 2, my lord.
private respondent.
No, not private respondent.
Who is the respondent?
Private respondent that they have been received, my lord.
Who is the respondent number 2?
Respondent number 2 is, my lord, the electricity, West Bengal State Electricity Distribution Company.
WBSCDCL. Yes. So what is the main prayer in the writ application?
My lord, prayer is at page, my lord. Page 19, my lord.
Electricity connection of the telecom of the said telecom BTS tower of the petitioner at the Mission Road, Kavi Navi Sonso, authority of management. Where is the document that you are enjoying the electricity connection prior to that? When it was disconnected?
My lord, that was disconnected, my lord. It was informed disconnection, my lord, on 28th of September 2024, my lord.
Where it is?
My lord, page 32, my lord. Last annexure, my lord.
32.
Yes, my lord. And thereafter, my lord, the several discussion was held with the respondent authorities, my lord. And ultimately, my lord,
Station.
my lord, at the very first line, and this is to inform you that on 28 September 2024 at about 1:30 p.m., our maintenance team went to the maintenance work at Mission Road Mobile BTS site in the rented premises of late Vishwanath Kundu. Sri Prabhat Kundu, son of late Vishwanath Kundu, obstructed them to enter into the premises to run their routine maintenance work of the machinery and other equipment which are the exclusive property of the BSNL, and shut down the electricity connection of the telecommunication equipment of the site and locked electricity meter box. Sri Partho Kundu was requested verbally and in writing several times to allow us to enter into the premises and restore the site, but he denied. It is further to mention here that the matter is still sub judice before the Ranaghat Court, having case number 22 of 2024 against the order of title suit number 62 of 2021. That is related to the eviction suit.
Yes.
Several discussion was held with him on 29.
What is the civil suit pending?
Civil suit, for regarding the eviction,
Against?
Against the BSNL,
Who has filed the civil suit?
The BSNL is the tenant in that.
You are for the BSNL.
Yes, I am for the BSNL.
So who is the owner of the property?
Property owner is the private respondent kindly. That is the Orunima Kundu.
Orunima Kundu.
Orunima 7 and 8,
7 and 8. So what
and
is the
Partho,
eviction of the BSNL from the property in question?
Yes.
Then?
Actually, what happened, original owner was their father,
Okay, whatever it may be. So they have disconnected.
Father and the BSNL.
Where is the representation to the WBSCDCL?
Yes, yes, that was short,
Where is your request to the
the station man 334.
Where is the representation you made for the restoration of the electric
Yes.
the WBSCDCL?
Yes. That on that day also, that copy was given,
How the
the 10th October, 1st October 2024, 4th October 2024.
Where is that?
Page 31, 32,
Page 31, 32 BSNL.
That copy was also, given to the electricity authority also,
The private respondents.
Yes, that
So where is the request to the WBSCDCL for restoration?
Yes, my lord.
Where is that?
My lord, that
and the suit is against you. Already expiry decree is passed against you, and you filed an application under order 9 rule 13 of the CPC for recalling of the expiry decree.
My lord, that is pending.
Correct. That's why now, as on date, there is a decree against you.
Yes, my lord.
And you are not appeared in the suit. And you have not made any request.
Yes, suit is
made any request.
Suit is my lord contested, my lord.
Not contested. It is the expiry decree against you. When we
Malad,
come to the page 33.
yes, Malad. Thereafter, they have
There
filed.
is an ex parte order. They filed the execution case. And then you filed an application under Order 9 Rule 13.
Yes.
That is pending, and
That
you
is
put in
pending.
an application before the executory court,
Yes, yes.
execution court for stay
Yes.
of the execution. The execution is stayed, and you are Order 9 Rule.
Yes,
What
yes.
happened to the Order 9 Rule 13?
That is pending, my lord.
Pending. It is not yet been decided.
That has not been decided.
And where you have not made any representation to the WPS judicial, what the court will do? Without
my
representation, you file this writ application for directing the restoration of the electric connection.
My lord, my instruction is, my lord, the copy of the page 31, 32. My lord, that was also given to the concerned electricity authority, my lord.
31, 32.
Page 31, 32, my lord.
Request to necessary support for
The copy was given, my lord.
Copy was given, but request where is the copy? No copy. 31, 32 is the inspector in charge. 31 is to Partha and Nirudakundu, and 30 is also the same private respondent.
Yes, my lord.
Not to the WPS.
That is, yes, addressed to the authorities, but
The petitioner has filed the present application being CAN 1 of 2025, praying for recalling of the order passed by this court dated 18 September 2020.
and my lord, for a moment, my lord, kindly come to the page 33. That is stayed, my lord. That page 33. My lord, last two lines. Let the title execution suit number be such and such, same in state till disposal of the miscase number such and such.
WPA 21844 of 2025 is dismissed for default for non-appearance of the parties when the case was called. The counsel for the petitioner submits that. When the case was taken up for hearing on 18th of September 2025, the learned counsel for the petitioner was not able to appear before this court as the petitioner was arguing the matter before court number 8. And immediately
May I pray one thing, my lord?
Came to know that this court has dismissed the writ application for default. Immediately on 24th of September 2025, the petitioner has filed the present application for recalling of the orders. The petitioner has filed the affidavit of service showing the service upon all the authorities, all the respondents, but the respondent number 2 refused to accept the affidavit of service. Consider the submission made by the counsel for the petitioner. This court found that the petitioner has shown sufficient cause. Accordingly, CAN 1 of 2025 is this court. Now the case is taken up for hearing on merit and disposed of. Position WPA number 218 restores its origin. Now this court has taken the writ petition on merit. Hearing on merit. It is found that the petitioner advances before this court that the private respondent, the petitioner is having the telecom BTS tower in the premises of the private respondent. When the petitioners had been to the tower, find that the electric connection has been disconnected. Accordingly, on 4th of October 2024, the petitioner has made a complaint to the inspector in charge of Ranaghat police station, as well as Ranaghat police station, for taking appropriate steps. The petitioner has also sent a request to the private respondents for reconnection of the restoration of the electric connection, but the same has not been restored. Accordingly, the petitioner has filed the present application. This court finds that in the prayer portion, the petitioner has prayed for a direction. For grant of electricity, for restoration of the electricity connection. But the petitioner has not made any request to the WBSCDCL for restoration of the recoveries. The petitioner has made a request to the private respondent. This court also find that the private respondents already initiated a civil suit against the petitioner and has obtained the ex parte decree, as the petitioner being the defendant failed to appear in the suit. Subsequently, when the private respondents filed an application for execution of the decree, the petitioner has filed an application under Order 9, Rule 13 of the CPC for recalling of the ex parte decree and prayed for stay of the execution procedure. Accordingly, London Civil Judge Senior Junior Division First Court Ranaghat Nadia has stayed the execution proceeding, and the Order 9 Rule 13 of the CPC is still pending. Though the petitioner has made the WBSCDCL as a party in the present case, but no representation has been made to the WBSCDCL for restoration of the electric connection. Full electric connection. The petitioner has made a request to the private respondent, but against the private respondent, this court cannot pass an order for restoration of the electric connection, as the dispute between the parties is pending before the London Civil Court. Accordingly, this court did not find any merit in the presented application. Accordingly, WPA number 20 is dismissed. However, the dismissal of the presented application will not prevent the petitioner for taking appropriate steps for restoration of the electric connection before the appropriate authority.
One liberty may be given to made a representative before,
Given, not prevent to make appropriate steps for
and the authority will take appropriate steps. Considering my representation. Instead of dismissal, dispose of.
Yes. Item number 6.
Item number 6 is my application, Your Lordship.
Yes.
I'm for the petitioner in this matter.
Yes.
In this matter, Your Lordship, on the last occasion, I had conveyed to Your Lordship that the petitioner had obtained
My lord,
14 loans.
perhaps Mr. Banerjee, our matter is item number 7.
My apologies in that event, Your Lordship. My apologies.
Apologies, my lord.
Though the matter is listed as urgent motion on the prayer made by the counsel for the petitioner, but when the matter is called, none appears on behalf of the petitioner, no accommodation is sought for. Let the matter appear in the combined monthly list of January 2027. Next.
Lordship, in item number 7, I'm appearing for the Axis Bank, Lordship. Petitioner has
Axis Bank.
Axis Bank.
I have instruction to appear. Take the appropriate action.
Item number 7, I am the petitioner, Your Lordship.
My lord, I am appearing
this
for
event.
respondent number 2, Reserve Bank of India.
I'm for the respondent number 556814.
On the last occasion, I had submitted before Your Lordship that though I'm an MSME and I had obtained 14 loans from the respondents, and I had sought restructuring of my loans under the Framework for Revival and Rehabilitation of MSME circular dated 17th of March 2016. Despite this being the settled position that now the financial institutions would have to mandatorily comply to the terms of the rehabilitation framework for revival and rehabilitation, I had not been given, despite the appropriate application being made, appropriate representations being made, I was not granted the restructuring under the framework, despite me being eligible and despite the petitioner having made the appropriate representation within the appropriate time, Your Lordship. I have annexed all relevant documents in the volumes. On the last occasion, Your Lordship, a question fell from the bench that at this point of time, they perhaps cannot classify the account as NPA because of the extant Supreme Court decision in Pronits. Now, I'm relying upon both the Pronits decision and the subsequent decision of the Honorable Supreme Court in Sri Sri Swami Samarth Construction and Finance Solution versus the Board of Directors of NKGSB, wherein the Honorable Supreme Court has once again reiterated that if an MSME seeks to avail the framework for revival and rehabilitation prior to classification and prior to steps being taken, initiated under the SARFACI, then it is mandatory for the financial institutions to grant the adequate opportunity. Now, my representations, Your Lordship, I had started making my representations. First of all, my registration is undisputed. That is at page 41 of volume 1. I started making representation, Your Lordship, from 8th of October 2025 to all the concerned financial institutions. Now, despite my representation, that is, page 41 is my registration, Your Lordship. Page 33. Page 33 of volume 1, Your Lordship.
Going into the merit. Now, my lord, before going into the merit, my lord, I have a point of maintainability. Since, my lord, I couldn't get that chance, Mr. Banerjee just started the matter.
Challenging maintainability?
Yes.
Yes, what is the point of maintainability?
My lord, if your lordship kindly sees the prayers one. Page 27, my lord.
Yes.
My lord, my learned friend has prayed for implementation of those circular passed by the RBI on the private parties.
On the private party?
All the other than Union of India and Reserve Bank of India, all the parties are private parties.
Where?
My kindly comes to the cost title. That starts from page 2. My lord, 3, 1 is Union of India, 2 is Reserve Bank of India, 3 is Poonawalla private party, 4 is ECL private party, 5 is ICICI Bank private party, 6 is Axis Bank private party, 7 is Kisatsu Saizan private party, 8 is private party, 9 is SMFG private party, 10 is private party, 11 is private party, 12 is private party, 13 is private party, 14 is private party. Now, my lord, so far their pair is that the circular issued by the respondent number 2 that has not been followed by these private parties. Although they have not taken this point or they have not challenged whether they have made this representation before the Reserve Bank of India, before the Ombudsman, that these private parties are not complying with the circular passed by the Reserve Bank of India. So, in my humble submission, my lord, this petition is premature. Before availing those redressal, my lord, they have approached before your lordship. That is my point of maintainability. And so far, my lord, these parties are concerned against the private parties, subject to correction, REIT is not maintainable.
Okay.
May I respond, Your Lordship? May I respond?
Petition is a premature petition.
Yes, yes. May I respond to that, Your Lordship? Your Lordship will straight away. Now the issue that the compliance of the framework for rehabilitation and revival of the MSME is binding on all financial institutions, including the NBFCs and the bank. It has now been settled by the Honorable Supreme Court in its decision in Pronits. May I just place Pronits once, Your Lordship? Since this point is being taken, may I just place that? I request Ms. Chaudhary to kindly hand up the decision of Messrs. Pronits versus the Board of Directors of Canara Bank.
I have.
This is.
Yes.
And may I
Your
hand
Lordship
up
will straight
SCC
away.
copy that will help your lordship. This is a reported copy.
Reported. Yes.
I'm reading from the INSC copy, the common citation copy. Para 2, Your Lordship.
Mr. Banerjee, could you just give the reference, please?
The reference of the common citation is 2024 INSC 565.
Thank you.
2024
It
SCC
will
online.
better the 2024 SCC online Supreme Court 1864.
Correct. My
Yes.
only apprehension is that the paragraphs may not tally, so your lordship will kindly bear with me. I'm reading for the INSC copy for the
Okay,
time
okay,
being.
okay,
I'll give
okay.
the references.
No problem, no problem.
Para 2, Your Lordship, whereby the High Court has dismissed the said writ petitions by holding that banks, non-banking financial companies, Your Lordship will very important, will kindly mark that, are not obliged to adopt Para 2 about 6 lines from top, Your Lordship.
Parato.
About 6 lines from top, Your Lordship.
Yes.
Whereby the High Court has dismissed the said writ petitions by holding that banks, non-banking financial companies are not obliged to adopt the restructuring process as contemplated in the notification dated 29th May 2015 issued by Ministry of Micro, Small and Medium Enterprises on its own without there being any application by the petitioner's MSMEs. This is the issue. Whether the framework for rehabilitation and revival is binding on banks and NBFCs or not. Now, Your Lordship, Para 4, the factual conspectus of the challenge is laid down. In the facts of that case, the NPA classification had taken place and SARFAESI proceedings had commenced. Proceedings under 13.2, 13.4, they had commenced. Now, in those facts, Your Lordship, will kindly straight away come to the finding of the court at Para 6 and 7. May I read? Before delving into the issue involved in the instant appeals as to whether the notification dated 29/5/2015 issued by the central government in exercise of powers conferred under Section 9 of the MSMED Act as revised from time to time is mandatory or directory, let us have a glance over the relevant provisions of MSMED Act. It will be noted that the very object and purpose of the MSMED Act is to provide for facilitating the promotion and development and enhancing competitiveness of MSME enterprises and for matters connected therewith and incidental thereto. Section 9 thereof empowers the central government to take measures for the purpose of facilitating such promotion, development, so and so, specifying the programs. Section 10 of the MSMED Act states that the policies and practices in respect of credit to MSME shall be progressive and such may be specified in the guidelines and instructions issued by the Reserve Bank from time to time to ensure timely and smooth flow of credit and such minimize the incidence of sickness among the and enhance the competitiveness of such enterprises. At this juncture, it would also be apt to refer to relevant provisions contained in Banking Regulation Act, then Banking Regulation Act, Section 21(3) of Banking Regulation Act, and 35 capital A of Banking Regulation Act is referred to 9 and 10. Your Lordship, the findings are recorded.
Yes.
Section 21 read with 35A makes it clear that directions issued by Reserve Bank to the banking companies are binding on them and they're bound to comply with such directions. As stated earlier, the whole controversy in the instant appeals centers around the notification dated so-and-so. In exercise of powers conferred, the said notifications contains the instructions for framework for revival and rehabilitation MSME. The relevant part thereof is set out. 13 is the ratio, Your Lordship. 13. And I'll just read some parts of 14 as well, Your Lordship. In view of the above, it is absolutely clear that the instructions for the framework for revival and rehabilitation of micro, small, and medium enterprises, as notified by the central government, vide notification dated so-and-so, in exercise of the powers conferred under Section 9 of MSMED Act, as revised by the RBI notification dated so-and-so, and the master direction of Reserve Bank lending to micro, small, medium enterprises directions issued by the Reserve Bank of India in exercise of powers under Section 21 and 35A of Banking Regulation Act, having statutory force, are binding to all scheduled commercial banks licensed to operate in India by the Reserve Bank of India as stated in the said directions. Now, Para 14 is relevant to the facts of this case, where the provisions of SARFAESI had already been triggered. Now, the last 4 or 5 lines at page 14, internal page 14, I'm just referring to show that it was laid down However, pertinently, the whole process of enforcement of security interest, as contained in Chapter 3 of SARFAESI Act, could be initiated only when the borrower makes any default in repayment of secured debt or any installment thereof, and his account in respect of such debt is classified by the secured creditor as a non-performing asset in view of 13(2) of the said Act. Now, para 18, para 17, it says that MSMEs have to be vigilant. They have to make the application prior to the classification and initiation of SARFAESI proceedings. Para 18, last 3 lines, Your Lordship. It holds that it has statutory force and would be binding. Here in the facts of the case, it was banking companies, but in the issue, Your Lordship has kindly noticed, it mentioned banking companies, banks, and NBFCs. Now, this was the first decision. Now,
Yes.
following this, Your Lordship, following this, in Samarth Construction, I request Ms. Chaudhary to kindly hand up the decision of the Honorable Supreme Court in Sri Sri Swami Samarth Construction and Finance Solutions. The reference is 2025 INSC 908. Your Lordship will kindly come to para 2. The petitioning enterprise had executed a loan agreement with NKGSB Cooperative Bank, but had failed in its obligation to repay the loan. In due course, the account of the petitioning enterprise was classified as an NPA. The authorized officer of respondent number 2 issued a demand notice under 13(2) of the SARFAESI Act, calling upon the petitioning enterprise to repay the dues of respondent 2 within 60 days. It does not appear from the writ petition filed that the petitioning enterprise objected to the classification of its account as NPA as well as issuance of the demand notice on ground that the action of the respondent number 2 was in violation of notification dated 29th May 25 containing framework for revival issued by the Joint Secretary. The respondent number 2 having moved an application before the relevant magistrate under 14. So again, in this case, Your Lordship, 13(14) of SARFAESI Act had already been triggered. Now, in that circumstance, the Honorable Your Lordship will kindly straight away come to the ratio. Para 8. And this is very vital, Your Lordship. It follows pronits and it gives the lays down the ratio and the contours of the pronits, that where it can be used, where it can't be used. Pronits is a decision of a coordinate bench of this court holding inter alia that the notification is binding on, Your Lordship will mark that kindly, lending banks stroke secured creditors. Finding to the contrary by High Court of Bombay in the judgment, an order under challenge in the appeal was thus quashed. Though, while stressing the terms of the framework need to be followed by the lending bank secured creditors before account of an MSME is classified as an NPA, the decision also lays down the obligation of MSMEs by holding it would be equally incumbent on the part of MSMEs concerned to be vigilant enough to follow the process laid down under the said framework and bring to the notice of banks concerned by producing authenticated and verifiable documents, materials to show its eligibility to get the benefit of the said framework. It was cautioned that if such enterprise allows the entire process of enforcement of security interest under SARFAESI Act to be over, or it having challenged such action of the bank creditor concerned in the court or law tribunal having failed, such enterprise could not be permitted to misuse the process of law by thwarting the actions taken under SARFAESI Act by raising the plea of being an MSME at a belated stage. This decision, however, left unsaid something which we have explained here and above while construing the terms consistently to prevent undermining the rights that one central enactment confers to another. So this says that before SARFAESI proceeding has commenced, it has been taken to some conclusion, this framework should be availed of. And this is mandatory in its terms, following pronits. Now, in our case, Your Lordship, so the first question, to answer the issue of maintainability, these frameworks are equally binding on private banks as well as financial institutions. Secondly, there are many judgments, including the celebrated decision of Federal Bank Limited versus Sagar Thomas and Your Lordship, KK Saxena versus International Commission on Irrigation, which categorically lays down that even a private body, such as an NBFC, if it is performing a public duty, and it defines what is a public duty, any compliance of a statutory mandate comes within the purview of a public duty. That would be amenable to the writ jurisdiction. Had it been only in the domain of a contractual dispute, then that will be excluded. May I just in this regard, very quickly, since the issue of maintainability has been raised, hand up Federal Bank versus Sagar Thomas and others, 2003, 10 SCC 733.
Yes.
Your Lordship will straight away come to para 27. Para 27 and 33. I'll just quote two paragraphs, Your Lordship.
Yes.
Such private companies, Your Lordship has found para 27. Such private companies would normally not be amenable to the writ jurisdiction.
Paragraph.
Article 27, Your Lordship. 27, page 756 of the judgment.
Yes.
Such private companies would normally not be amenable to the writ jurisdiction under Article 226 of the Constitution. But in certain circumstances, a writ may issue to such private bodies or persons as there may be statutes which need to be complied by all concerned, including private companies. For example, there are certain legislations like the Industrial Disputes Act, the Minimum Wages Act, the Factories Act, or for maintaining proper environment, say the Air Prevention and Control of Pollution Act and Water Prevention and Control of Pollution Act, etc., or statutes of the like nature which fasten certain duties and responsibilities statutorily upon such private bodies which they are bound to comply with.
Yes.
If they violate such a statutory provision, a writ would certainly be issued for compliance of these provisions. Para 33, Your Lordship. Thereafter, if Your Lordship kindly takes paragraph 33 at internal page 758. For the discussions held above, in our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on statutory or public duty. A private body or person may be amenable to the writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligation or such obligation of public nature, casting positive obligation upon it. So mere carriage of banking under the contract is not, but a mandate of the statute is. Your Lordship, the next decision, Your Lordship, 2015, 4 SCC 670, the decision of KK Saxena, decision in the case of KK Saxena versus International Commission on Irrigation and Drainage and others.
Yes.
Your Lordship, para 40. Para 40, 43 and 45. Only 2-3 paragraphs I'll show and only relevant parts. It referred to Federal Bank versus Sagar Thomas at para 40.
Yes.
Inasmuch as in the case curled out, the categories of body person who would be amenable to the jurisdiction of the High Court. It quotes para 18. Now, if Your Lordship kindly turns over, Roman numeral 7, Your Lordship. Roman numeral 7, Your Lordship finds a private body discharging public duty or positive obligation of public nature. Now, this has been explained.
Yes.
Para 43, what follows from a minute and careful reading of the aforementioned judgments of this court is that if a person or authority state within the meaning of Article 12 of the Constitution, admittedly a writ petition under Article 226 would lie against such a person. However, we may add that even in such cases, writ would not lie to enforce private law rights. There are a catena of judgments on this principle of judicial review of an action under administrative law. The reason is obvious. A private law is part of a legal system, which is part of a common law, involves relationship between individuals such as law of contracts and torts. Therefore, even if writ petition would be maintainable against an authority, which is state under Article 12, before issuing any writ, particularly writ in mandamus, the court has to satisfy the action of such authority, which is challenged, is in the domain of public law, is distinguished from private law. Now, your lordship will kindly take 45. This is the paragraph. On the other hand, even if a person or authority does not come within the sweep of Article 12 of Constitution, but is performing public duty, writ petition can lie and writ of mandamus or appropriate writ can be issued. However, as noted in Federal Bank, such private body should either run substantially from state funding or discharge public duty, positive obligation of public nature, or is under liability to discharge any function under any statute to compel it to perform such statutory function.
Yes.
So what follows from all of these decisions is A, my submissions, I'm just crystallizing my submissions. A, that it has been held by the Honorable Supreme Court that this framework for revival and rehabilitation of MSME that has statutory force. It is mandatory for financial institutions, including banks and secured lenders of other nature, to mandatorily comply with it. Sagar Thomas, read with KK Saxena, categorically lays down, even if a private body is to statutorily discharge a public function, a mandate, has to comply with some policy. And what is the policy? That MSME should not be pushed into bankruptcy, should not be pushed into financial distress. Just like that, there is a safeguard. There is a mechanism that is built in that needs to be followed. Now,
Yes.
a mandate of such nature is a public duty under public law having statutory force. So this writ, in my humble submission, is maintainable.
Yes.
And insofar as the compliance of the framework and the rules given, laid down, the guidelines laid down in pronits and the subsequent decision of Samat construction, I have not waited to allow my accounts to become NPA. I have started addressing representations right from SME 0, SMA 1 stage. And all of my representations are on record, your lordship, at page 483 on volume 3 onwards.
Yes. Can you fill it at this?
Despite this, the second important point, I'm very grateful to my learned friend. I have made, your lordship will kindly note the date of my representations to the parties. The representations are all in October. 8th October 2025 is the commencement of the representation.
Yes.
I have made representations. Thereafter, your lordship, if your lordship kindly takes volume 8 at page 1152, I have made a representation to the RBI on 4th of November 2025, seeking direction from RBI that the respondents comply with the mandate of the framework. Page 1152, volume 8, your lordship. My apologies for the petition being bulky, your lordship, because I had to disclose my representations to all 14 respondents.
Yes.
1152 onwards, this is a representation dated 4th of November. So even prior to the first loan recalling notice, right in October and November, I made my representations, A, to the respondents and B, to RBI.
Yes.
So I have followed, and no surfacing proceedings, nothing has been initiated against me.
Yes.
Now in these facts, I have not received any reply. I have only received loan recalling notices thereafter. And those start from 11th of November 2025 onwards, without providing me the mandatory restructuring under the rehabilitation scheme. Now,
Yes.
I have not received a single reply to my representation that I have made to restructure my account. in accordance with framework. Your Lordship will kindly take my representation once. Any one, I will give the first representation at page 483. I have given my eligibility. I have given the details and particulars. My exposure is to the tune of 10 crores. So as long as it is below 25 crores, I'm eligible. Your Lordship will kindly take 483. This is the representation addressed to Poonawalla FinCorp.
Yes.
Your Lordship will kindly see. I'm an MSME. Loan particulars I have given. I have given my total exposure. At page 484, para 3, I have given my total exposure, 10 crores.
Yes.
Together with details of all facilities showing that I'm eligible
Yes.
to obtain this benefit. Now, despite this, I have not received any replies. They have not considered. So this non-consideration of my request for restructuring, availing the MSME scheme, is what I'm aggrieved by, Your Lordship. Now, what instead, the moment I have made these representations, what instead has happened, they have started issuing loan recall notices.
Where is the loan recovery notice?
Your Lordship will take 1159, page 1159 onwards, Your Lordship will see the loan recalling notices. And the factum of receipt of my representation is evident from the petition. I have annexed each and every email together with acknowledgement that they have received my representation. Yet, no reply. And subsequent recalling of loans starting from 11th of November 2025 at page 1159 onwards, Your Lordship. I have given my response to those notices. I have objected to them. Your Lordship will take, for example, one acknowledgement at page 1437. I had shown Your Lordship the representation to Poonawalla. I'm giving the page number of the acknowledgement. Page 1437. I have given everything. Now, in these facts, Your Lordship, my submission is, at this stage, what I'm praying for is, let them consider my application, my representation for restructuring of my account in accordance with the framework. That is all that I'm seeking. That is my prayer. And in the interregnum, let them not take any coercive steps in respect of the loan recalling notices. Otherwise, the entire process will become infructuous.
Yes.
Interim, if Your Lordship kindly takes my prayers, prayer A is the mandamus.
Yes.
For compliance of the scheme. B, E, and F, what I would be urging at this point, Your Lordship. Non-classification, consideration and disposal, and not taking any coercive steps pursuant to the loan recalling subsequent to my representation. That is all I'm seeking at this point.
Correct. That's all.
And two of the NBFCs had also initiated arbitration proceedings. That I have disclosed at para 12 of my petition, and I'm taking appropriate steps before the appropriate court, Your Lordship. That is a separate issue. That pursuant to this loan recalling notices, they have proceeded to initiate arbitration. Somebody has got a Section 17 interim measure issued against me, freezing my account, etc. That's a separate issue. That I'm contesting in the appropriate forum, Your Lordship. That is also under consideration. Those are my submissions, Your Lordship.
Yes.
My lord, so far, my point of maintainability. In reply, my lord, I will only delay one judgment passed by Honorable Apex Court. May I be allowed to hand up? আমি এসএসসি অনলাইন কপিটা দিয়ে দিচ্ছি, আমারটা পড়েও আপনাকে দিয়ে দিচ্ছি।
তো এয়ারড্রপ করে দিন।
হ্যাঁ, করুন, জাস্ট a minute.
You are appearing for
4, 5, 6. দেখে বলো, kindly allow me. 5, 6, 8, 14.
4, 5, 6, 8, 14.
5, 6, 8, 14.
Yes.
মানে সোফার রিপ্লাই করে দিচ্ছি, আমি এটা আপনাকে দিচ্ছি। এসএসসি অনলাইন কোথাও বলে দাও। হ্যাঁ,
Kindly give the citation.
2025 SCC online, SC 177.
2025.
SCC online, SC 177. I have given you the reportable, my lord,
Yes.
since I am not carrying hard
Yes,
copy.
yes. Which paragraph you are in?
Now kindly comes to paragraph 8, page internal page 10. And that is only towards the submission of maintainability.
Yes.
A body, public or private, should not be categorized as amenable or not amenable to read jurisdiction.
Paragraph?
No, paragraph 8, my lord. Okay. The most important and vital consideration should be the function test as regards the maintainability of a writ petition application.
Yes.
If a public duty or public function is involved, anybody, public or private, concern or connection that duty or function are limited to that would be subject to judicial scrutiny under the extraordinary writ jurisdiction of Article 226 of the Constitution of India.
Yes.
Now, my lord, the test were discussed. We may sum up thus: for issuing writ against a legal entity, it would have to be an instrumentality or agency of a state, or should have been entrusted with such function as are governmental or closely associated therewith by being public importance or being fundamental to the life of the people and hence governmental. 2. A writ petition under Article 226 of the Constitution of India may be maintainable against the state government, authority, a statutory body, an instrumentality or agency of the state, a company which is financed and owned by the state, a private body run substantially on the state funding, a private body discharging public duty or positive obligation of the public nature, a person or a body under liability to discharge any function under the statute to compel it to perform a statutory function. Although a non-banking financial company like the Muthoot Finance Limited, with which we are concerned, is duty bound to follow and abide by the guidelines provided by the Reserve Bank of India for smooth conduct of its affairs and in carrying on its business, yet those are regulatory measures to keep a check and provide guideline and not a participatory dominance or control over the affairs of the company. A private company carrying on banking business as a scheduled bank cannot be termed as a company carrying on any public function or public duty. Normally, mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. In exceptional cases, a writ of mandamus or a writ in the nature of mandamus may issue to a private body, but only where public duty is cast upon such private body by a statute or statutory rule, and only to compel such body to perform its public duty. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a particular thing, it does not possess the attribute of a statutory body. Then, last, if a private body is discharging a public function and the denial of any right is in connection with the public duty imposed on such body, the public law remedy can be enforced. The duty cast upon the public body may be either statutory or otherwise, and the source of such power is immaterial, but nevertheless there must be the public law element in such action. So my humble submission is that since there is a statutory body to look into the alleged fallacies made by the private respondents, they need to look into they need to look into that fallacies first. Then, my lord, if they fail to do, then only jurisdiction of this honorable court comes in. So far, it is my main point of maintainability.
No, then they have made a representation to the RBI.
We have made a representation to the RBI. Your
And at there, I'll make some submission. I'm reserving my
Yes.
comments on that because I'm not
Written.
addressing on maintainability
My only
at the
question
moment.
is that
Absolutely. We are only on the aspect of
But
only aspect of
but that is the
maintainability. We have,
statutory-
In that case, kindly comes to the prayer then. It is page 27.
Yes.
First, a writ, order, or direction in the nature of mandamus to issue commanding the respondents and each of them to forthwith consider the representation submitted by the petitioner. My representation means representation for restructuring, submitted by the petitioner for initiation of revival and rehabilitation process in respect of a loan account in strict accordance with the Reserve Bank of India's framework for revival or rehabilitation of micro MSME. Then again, my lord, the second pair, a writ order direction in the nature of mandamus do issue commanding the respondents to comply with the MSME framework along with the operating instruction notified by in communication rate so and so. Again, my lord, that circular. Let's see a writ order and writ order direction in the nature of certiorari do issue commanding the respondent number 6, 9 to 12 to cancel, rescind and or withdraw and quash and set aside the loan recall letter. That is the initiation of legal process.
Yes.
Then, my lord, a writ order and direction in the nature of prohibition to issue restraining the respondent number 3 to 4 for classifying the loan accounts as mentioned in the paragraph 4 herein above. Again, my lord, that action. A writ order and direction in the nature of prohibition to issue restraining number 6, 9 and 9 to 12.
Okay. Then.
So, my lord, there is no such prayer as against the respondent number 2 who is required to look into the allegations of the petitioner. And so far, these circulars are concerned. If your lordship kindly takes up the judgment relied by my learned friend Pronitz, which was followed by the another judgment. If your lordship kindly comes to paragraph 16 directly, and I have handed up reported copy to your lordship.
Yes.
May I?
Yes.
We may hasten to add that under the framework of revival and rehabilitation of micro, small and medium enterprises, the banks or creditors are required to identify the incipient stress in the account of the micro, small, medium enterprises before their accounts turn into performing assets by creating three categories under the special mention account category.
Correct.
However, while creating such subcategories, the bank must have some authenticated and verifiable material with them as produced by the concerned micro, small and medium enterprise to show that the loan account is of a micro, small and medium enterprise. So, I am pausing here for a moment. So, in my humble and my understanding, that first criteria is the eligibility criteria of that amount. It has to be 10 lakh to 25 crores. Now, the second, the product granted in favor of the petitioner hearing has to be in the nature of MSME.
Correct. The memorandum or the notification specifically says that if it is the loan is granted under the MSME.
Under the MSME, right.
Under the MSME.
Right.
If when the loan form was submitted and it was granted under the MSME, so it is the knowledge of the bank. It is the knowledge of the bank. If suppose,
and I have given all representations, your lordship, including my MSME qualification.
Mr. Banerjee, kindly allow us.
If it is not, then before NPA, before declaring NPA, so you have to verify the document whether it coming under the MSME and whether it is covered under this and this notification. Then you can declare the NPA. This is the.
May I differ slightly, my lord? Yes, if it is a MSME company and the MSME company has availed a product under the MSME.
Correct. That's entirely.
Which has a MSME exposure.
Correct. Because the loan,
yes,
when the person or company or the firm applied for the loan, it is specifically mentioned.
No, my lord, subject to correction, my lord.
Yes.
A MSME can avail MSME loan as well as non-MSME.
Correct. That's right. So it is mentioned it is under the MSME.
Under the MSME.
That's I'm telling. It is under the MSME or not under the MSME.
My lord.
So it has to be clarified.
It has to be clarified.
So that's why the court has stated that you have to see under which category the loan was granted. Then only you can. So
Yes.
subsequent, you cannot say no. It is the petitioner has to establish.
No, my lord, I am not on that. I have to satisfy your lordship
Correct.
that the petitioner has taken out certain information that I have availed certain credit facility from the respondent. Now the respondents here to assist your lordship by maybe by way of an affidavit, short affidavit, that the credit facility is granted in favor of the petitioner hearing, whether comes under the purview of MSME or not. That is the first.
That is the first criteria.
First task I need to assist your lordship.
Correct. That is the first criteria.
Yes, one of first task I should assist your lordship in that.
Yes. No.
In that case, kindly allow me to use short affidavit only to disclose that the credit facility is granted in favor of the petitioner comes under the purview of MSME only towards that.
That is the only thing.
That is the only.
If it is produced, then it's nothing.
If it is there under the MSME, it will attract. If it is not, it will not attract.
Well, just to add to my whatever submitted by my learned friend, I represent respondent number 12 in this matter. So respondent, to an extent, respondent number 12 is concerned, no such application has been made. However, my lord, what we are losing a sight of is the circular on the basis of which my learned friend is claiming the benefit. If my lord, I'll just invite my lord to take the circular once, because the representations that has been made by him is not in correct form or not as per the circular that is there. Because just by making a representation through the branch manager, you cannot get the restructuring. That is what the RBI has said in their circular. Allow me to place the circular, and then my lord consider whether the representation that has been made are in consonance with the circular or not, against which the respondent has to consider their request. If my lord kindly takes up the circular of 2015 once, it perhaps starts at page 394. Because what Pronitz has said, and subsequently by the judgment of Justice Datta, everywhere it has been cleared. Few things has already been cleared that they are supposed to get the benefit, but the application has to be in accordance with the circular. Kindly, my lord. Page, perhaps it 394. Which volume? Volume 3, my lord.
Yes.
Yes, my lord. So, my lord would see there are two conditions for identification of the incipient stress.
Yes.
One, by the bank or financial institutions themselves, or second, by the borrower or whosoever, that the customer himself. So, my lord, here my learned friend, the writ petitioner, is trying to invoke the writ jurisdiction on the second point, that he himself has identified the incipient stress and he should get the benefit. So, my lord would kindly take the number 1 and then sub 2 just after the SMA 0, SMA 1 and SMA 2. My lord has got that. Identification by the enterprise. Any micro, small or medium enterprise may voluntarily initiate proceeding under this framework if the enterprise reasonably apprehends failure of its business or its inability to pay debts, and before the accumulated loss of the enterprise equals to half or more of its net worth. The application for initiation of the proceeding under this framework shall be verified by an affidavit of the authorized person. When such request is received by the lender, the account should be processed as SMA 0 and the committee, kindly mark the word, the committee under this framework should be formed immediately. Now, my lord, kindly come to, ignore 2 and kindly come to 3. Composition of the committee for the stress micro, small, medium enterprise. The constitution of the committee shall be under the regional or zonal head of the bank, who shall be the chairperson of the committee, officer in charge of the MSME department of the bank at the regional or zonal office, who shall be the member of the convener, one independent external expert with expertise in MSME related matters to be nominated, one representative from the concerned state government. The composition of the committee, the terms of the appointment of its member and the manner of filling the vacancies and the procedure to be followed in the discharge of committee's function and may be prescribed by the board. Now, my lord, application to the committee for the corrective action plan. This is what my learned friend wants to invoke.
No, Mr. Guha, that is not what I have read. I have made an application for invoking under Regulation 1, identification of incipient stress
So
and triggering the MSME. Corrective action plan comes after recognition, after authorization, and then classification. Very well, very well.
So once he has identified that thing, obviously the bank is not going to decide. It has to be decided by the committee. And how the process has to be followed.
No. Committee will come later on. First, the bank has to identify whether it is coming under the MSME.
No, my lord.
And once the bank has decided it is coming under the MSME, then it will be taken back to the referred to the committee. Then committee will decide whether he is entitled to get the benefit.
Now, my lord, over here there is one difficulty which I will just show from this thing, because my learned friend does not have only one financial assistance that has been granted by one of the financial institution. Here he has taken a loan from at least 10 to 12 institutions.
Correct.
So what would be the circumstances for deciding this thing at that juncture? That is why I wanted to.
That is a secondary question in my humble submission.
Provide.
That is after entertaining my application. Today, my application has not been entertained.
And may I come in some assistance? I'm appearing for Reserve Bank of India in the matter.
Yes.
So
Just to cut
just-
short the matter, because as I understand on the maintainability point, the parties have made their respective submissions, but I am not on maintainability because so far as my stand is concerned, the framework does have statutory force. It is, yes, and time and again, it is not only about pronix. Time and again, it has been held by the Honorable Supreme Court that all these master guidelines or the framework which are done by Reserve Bank of India, they are under the powers of Section 21, read with Section 35A of the Banking Regulation Act.
Correct.
So those are mandatory and those are binding on all the financial institutions.
Correct.
A. B. Now, regarding this particular application, which was made to Reserve Bank of India at least, because here I'm only going to address before your lordship, what is the stand of Reserve Bank of India? What has been placed before your lordship by the petitioner is page number 1152, which is also appearing at page number 1244. Same document, either of the two, if your lordship takes up. It is a communication dated 4th of November 2025. But your lordship will see that it was reserved. It was received by Reserve Bank of India on 14th of November 2025. The stamp and seal is there on the document itself, which shows that it was received on 14 November 2025. Now, after this was received by Reserve Bank of India, the communication which was issued in response by Reserve Bank of India on the same very day to the concerned advocates from where the letter had came. If my learned junior who is present in court, Ms. Banerjee, would hand over a copy of that before your lordship will see that we had indicated that because it is regarding a deficiency of service on the part of the financial institution which has been complained of, therefore it has to approach in a particular way. And we had requested them to lodge the complaint in RBI CMS portal. We had given all the details and we had asked them to do so. But however, despite receipt of this, this document has not been disclosed in the voluminous papers which are before your lordship in the writ petition. Next, on the 14th of November, after receipt of this communication, they did not lodge the complaint with the CRPC, which is the Banking Ombudsman section, which is going to address under a particular mechanism. And it will be taking the cause of the petitioner once the complaint is lodged in a proper form. A. Then your lordship will turn to what my learned friend who is appearing for the bank was making submission before your lordship, the concerned framework. Now your concerned framework starts at page number 362, volume 3, which is the upgraded version dated 17th of March 2016. Now your lordship will kindly look at page number 364. 364. Clause 2 thereof. As I understand from the submission made by the learned counsel appearing for the petitioner, The contention is that they had made the application by themselves because there are two mechanisms prescribed under this particular framework by
Yes.
which the complaint could be lodged. Either directly the bank could take it up, or the petitioner can also could have taken up. So under this particular regulation 2, identification of incipient stress, your Lordship will find 2.1 speaks of identification by banks or creditors. Now, pausing here for a moment, if your Lordship turns the page, 2.3, that is page 365, your Lordship. Clause 2.3 is the relevant clause under which the petitioner gets the right to approach directly.
Correct.
So, identification by the borrower enterprise. Any MSME borrower may voluntarily initiate proceedings under this framework if the enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts, or there is erosion in the net worth due to accumulated losses to the extent of 50% of its net worth during the previous accounting year, by making an application to the branch. So first part is either application to the branch or directly to the committee. So there are two ways. Even when it comes to the borrower enterprise, he can either directly make an application to the committee or to the bank, as referred in para 3.3, wherever applicable. When such a request is received by lender, that is in the first instance, by the bank, then the account with aggregate loan limits above rupees 10 lakh should be referred to the committee. So it is binding on the bank to refer it to the committee straight away. If the bank would have received the complaint, or the committee should convene its meeting at the earliest but not later than 5 working days from the receipt of the application. So in this particular case, there are two things. If the petitioner is aggrieved by the action of the regulated entities, then he could either approach, by reason of this particular framework, either approach the regulated entity directly or directly the committee. Either ways, not later than 5 working days from the receipt of the application, the account has to be examined for a suitable, which is the second part of it, that is corrective action plan. CAP is corrective action plan. That is under clause 4. So we are at this first initial stage. So first, it would be, I think, beneficial for the parties to produce sufficient records that aid whether it is the MSME loan that was advanced to this particular entity. Because what I find personally, if your Lordship turns now to the pleadings which are before your Lordship in volume 1,
Yes.
your Lordship will kindly take up paragraph 4 of the petition. So that enlists 21 institutions from where the loan have been taken, availed of by the writ petitioner. And the total of it comes to 9,61,90,822, which I have done my own calculation to understand what was the sanction limit granted in total.
Yes.
So first, the
what is the total? What is the total amount? It's coming.
total
10 crores,
amount
Your
is
Lordship. It's around 10 crores.
961,90, then 822. That is the precise calculation of the total breakup which have been given in the table above.
Yes.
So
in my representations, I have disclosed the amount, exact amount. It is slightly more than that.
Just CS calculated, then my yes.
Yes. Now, for your Lordship to decide, because one of the prayers is to consider the application representation made by the petitioner. Now, so far as Reserve Bank is concerned, Reserve Bank has given a response which I have shown, and there has been, which is not disclosed in the voluminous papers, and the writ petitioner has not approached the concerned unit of the Reserve Bank of India by the proper channel. So nothing could have been done so far as Reserve Bank of India is concerned. Now, so far as the affidavits are, as my learned friends have indicated, if your lordship would like to elucidate, because it can only be elucidated on documents as to whether it is in the nature of a loan that is granted to the MSME loan or not.
Okay, that's it.
Lordship, may I just very quickly in 30 seconds just rejoin
Yes,
to
yes,
whatever has been submitted by everyone? Just 30 seconds.
Yes,
The
just Mr.
issue
Banerjee, I
regarding-
will hear you. I will hear. Yes, let me
Very
respond.
well. Very well. If Mr. Guha could kindly speak to the microphone, because I wouldn't be able to hear.
Can you hear me? Yes. So,
Yes,
my lord,
yes.
I'll just, this is page number 365 once. Because, my lord, here what needs to be looked into that there is a multiple banking arrangement to an extent. Why I say multiple? Because he has availed a loan from 10 to 12 organization. So, when he is looking for a restructuring, he is looking for a holistic restructuring for this entire situation. My lord, 3.2 deals over here. Because my learned friend has already showed that to an extent this it can either be done by himself or he may refer it to the committee. 3.2 is something, my lord, which is perhaps pertinent for MSME borrowers having credit facility under a consortium of bank, which is perhaps not his case, or multiple banking arrangement, perhaps he is coming under this. The consortium leader or the bank having the largest exposure to the borrower under MBA, as the case may be, shall refer the case to its committee. If the account is reported as stressed, either by the borrower or any of the lenders under this framework, this committee will also coordinate between the different lenders. So, RBI, why putting this clause over here? In order to get a holistic result. And when there is a multiple banking arrangement and when there are several banks are involved, so he has to make the application to the committee so that the committee who is having the largest exposure, that, my lord, 2015 clearly says that the bank who has the largest exposure will coordinate with all the other banks, set up this committee and decide his issue. Perhaps in this particular matter, my learned friend has just written to respective branches. He has not taken any steps of referring the matter, because every bank or the institution has this committee, referring this application directly to the committee. To an extent, now coming to whom I am representing, that is respondent number 12, no such representation has been made. So, first and foremost, to an extent, respondent number 12 is concerned, no such representation has been made seeking for restructuring. It is only that we have issued a loan recall notice to which my learned friend's client has responded. But otherwise also, if we go by the circular says, as shown by my learned friend representing RBI, that it has to be either by the to the branch or directly to the committee. In case of multiple banking, the largest shareholder of the advances shall coordinate. This, my lord, would.
But kindly come to this PROCEEDINGS judgment,
Yes.
paragraph 14.
Yes, madam.
That is, in my humble submission, an incorrect reading of the regulation. I will clarify.
Paragraph 14.
Yes, my lord.
At transferring, read it.
My lord, I'm completely with my lord in this thing. I am completely that it has a statutory force and it is binding. I'm not at all on maintainably. It has a statutory force, and time and again, my lord, Supreme
Not
Court has
statutory force. It required to be carried out the banking company before the account is been declared an NPA.
Correct.
My lord, there are two options to it. That's why the circular.
Not so. That is the point raised before this in this proceeding before the Supreme Court. That is the point, whether the petitioner has to intimate the bank or the bank has to. Now the court has held, no, it is the duty of the bank. You cannot take the plea.
My lord, in that event,
informed
yes,
that he has availed the MSC bank. That's why the bank can initiate the NPA. And bank has to see whether the NPA, the loan is under the NPA or not.
No, my lord, this is perhaps, my lord, when my lord
I
is at
think kindly
PROCEEDINGS.
read this, kindly, because I have dealt with
Yes,
such
my lord,
judgments.
I will invite my lord to kindly take paragraph 21 of PRONIT once. It is not the duty only upon the bank.
Yes, continue.
Kindly take paragraph 21 once of PRONITs. May I just please?
PRONIT 21.
PRONITs, para 21.
Of the reported judgment or the
Pronit's, my lord, this
Arise
is
the-
2000,
Judgment I have handed over.
No,
to you.
reported
2024.
not there.
Oh, I'm extremely sorry. May I just hand up, my lord, the report?
No, reported judgment, it is there.
My lord,
Report-
this is the SCC copy. SCC 2024 10 SCC 292. Because, my lord, what Pronit's, my lord, has just, yes, my lord has seen up till 16 to an extent that bank, it's
Yes,
the
yes,
duty, mandatory force, we are completely.
Yes.
But what 21 also said needs to be looked into.
Okay.
It is also pertinent to note, may I just?
Yes.
It is also pertinent to note that the sufficient safeguard had been provided under the said chapter for safeguarding the interest of the defaulting borrowers for giving them opportunity to discharge their debt. However, if at the stage of classification of the loan account of the borrowers as NPA, the borrower does not bring to the notice of the bank concerned that it is a MSME, MSME under the MSME Act, and if such an enterprise allows the entire process of enforcement of security under the SARFAESI Act to be over, or it have been challenged such action of the bank creditor concerned in the court or tribunal and having failed, such an enterprise could not be permitted to misuse the process of law for flouting the actions under the SARFAESI Act by raising the plea of being an MSME at a belated stage.
Correct.
Suffice it to say, when it is mandatory or obligatory on the part of the banks to follow the direction issued by the central government and Reserve Bank of India with regard to the framework for revival and rehabilitation of MSMEs, it would be equally incumbent on the part of the MSME concerned to be vigilant enough to follow the process laid down under the said framework and bring to the notice of the banks concerned by producing authenticated and verifiable document material to
Correct.
show its eligibility
Correct.
to get the benefit under the same. So, my lord, it is not only the bank, it is the my learned friends, clients also, which they have to an extent done. What I am trying to say is that first and foremost, to an extent, respondent number 12 is concerned, no such application has been made. To an extent, other things are concerned. In case of multiple banking, he has to apply before the committee. And because of the multiple bank, the highest lender has the charge to decide the entire issue, get in touch with the other lenders, create the committee, and decide on the action plans.
Okay.
So these are the things that needs to be looked at.
Thank you.
May I just very quickly in 30 seconds just rejoin your lordship? That is not a wrong reading of the
Yes,
regulation,
I
your
am on the
lordship.
30-second only.
Only 30 seconds. Only 30 seconds. What happens is when the bank identifies the incipient stress, then there is no question of application by me. The bank immediately classifies it as SMA 0 and forms a committee. In that case, the first option for the petitioner to approach is before the committee.
Correct.
That's why under 3.2, it is before the committee. Now, when the petitioner voluntarily identifies, it has to be to the designated official, which in this case is branch manager, which I have done. Scrupulously in meeting with the regulations, I have also filed my affidavit. So there is no non-compliance insofar as the form is concerned.
Okay.
Secondly, once I have identified, then it is mandatory because here voluntarily I have identified. So it's mandatory on the bank. So those are my submissions. Your lordship will kindly protect me in the meantime.
If I am here for the respondent number 10, my lord, there is a valid and persisting arbitration clause in the agreement, my lord, on the basis of which arbitration proceeding has challenging the jurisdiction of the arbitrator if a petitioner has approached this honorable court, my lord, and the judgment is pending on that. Whether the
Yes, I have already disclosed that. Your lordship. Those are my submissions.
Yes, application not printed.
Getting concluded. So you'll get the order. I'm not passing here.
Very well.
Because of the
Very
matter.
well. I'm deeply obliged, your lordship. I'm deeply obliged.
Thank you.
Grateful to
Deeply
you.
obliged, your lordship. Grateful.
Grateful, madam.
Item number 8. Thank you.
Item number 8, your lordship, I'm appealing for the petition.
ठीक से रखा नहीं टेबल बनवा बोलो yes
Your Lordship, I am for the respondent. The learned ASG is leading me. I've still not been able to get instructions in the matter. Item 8, Your Lordship.
why you're not taking action
Your Lordship, this matter has come up for the first time, Your Lordship. I have sought for instruction, madam.
What you applied for? Passport?
Yes, Your Lordship. I
Renewal of passport?
renewal of a passport, Your Lordship. I am the petitioner here. I am the single parent, single mother of a minor.
Your Lordship, on Wednesday, if the matter could be taken up, the learned ASG shall be.
Wednesday or Thursday, Your Lordship.
Thursday?
Thursday.
Learned Counsel for the passport.
I am
authority.
submitting my affidavit of service, Your Lordship.
Learned Counsel for the passport authorities prays for time for taking instruction. According cases adjourned, let the matter appear on 11th December. आज कितना तारीख? Yeah, 18th December.
Obliged. Your
Under the same heading.
Obliged.
Affidavit of service filed by the petitioner be kept with the record. Next.
Grateful, Your Lordship.
My lord, item number 7, may I file the affidavit of service? Item number 7.
Item number 7, yeah. CA में कर रहे हैं. Affidavit filed by the petitioner be kept with the record.
Grateful, madam.
Yes, next.
Well, this is my application. Well, I have come up before your lordship. My excise license was cancelled, but without following the due procedure of law, and that has already been held our High Court division bench. This is not as per the procedure of law, so far as the other person is concerned. But the facts, shortly I shall.
Is there any guidelines fixed by the authority with regard to the issuance?
Yes, yes. Lord, your lordship will find section 42 and 43, how a license can be cancelled. That was not followed. And exactly on this point, division bench of our High Court, asks the authority to pay the deposit which has been given by the petitioner. Now, shortly I shall place the facts before your lordship. First, your lordship kindly turn to page 26A. The petitioner was a valid license to deal with the poppy straw. And 26, page 26, your lordship will find the Kolkata Municipal Corporation has given trade license to deal with poppy straw also. 26 and 27, 26A.
For the coffee shop.
For what? Poppy straw. Dry fruits and poppy straw. Got it?
Yes.
Now, the authority, the license was given by the authority. Your lordship will get that reference in page 26A. Now, from page 27, your lordship.
What is the 26A?
26A by the Kolkata Municipal Corporation has given me the trade license.
And 26?
26, page 26. And 26A is given by the excise department.
Yeah, excise. You have a legible copy?
Page 62, your lordship will get that legible copy. Okay. The same copy. This is the document supplied by excise.
License possession. Yes.
This is in terms of 45 of the excise rule. The department was given license to me. Now, your lordship knows better than us. In 2012, the government receipt portal system, shortly known as GRIPS portal, it was introduced for the payment of all kind of government fees. So, from your lordship will get from 27 onwards till your lordship will find the last one is on page 35. Time to time, my license was extended and money was taken by the authority. But kindly turn to the last page, page 35.
Yes. It's a license fee of paid.
Yes, your lordship will get the license number, my mobile number, everything is there. License ID number, your lordship will get that.
Yes.
Until and unless I incorporate my license number, this portal will not open. And accordingly, I paid, and kindly see the period of validity also. 1/4/2019 till 31st of March 2020. Kindly mark this date.
Yes.
Now, all of a sudden, a FIR was registered against the present petitioner. The complaint was filed by the excise department. This is, we gravely this document, your lordship can peruse it, saying that
কপি দেবে দাদা যদি থাকে
এটা আমি তো রেফারেন্স করে তোকে দিয়ে দিচ্ছি।
ওকে, এটা কি পেজ 36 এরটা একবার দেখো তো, এটাই কি সেম তুমি যেটা দেখাচ্ছ?
Page 36
একবার দেখো, সাবজেক্ট টু কারেকশন, এটাই কি?
হ্যাঁ,
এটাই তো অ্যানেক্স
Yes.
করো, এটা দেখাচ্ছ তো?
Now, your lordship will find on 6/3/2020, although my license was valid and government has taken the money for the renewal of license, but lastly it was valid till 31st of March 2020, but 6th of March they raided my godown and they have found the commercial quantity of poppy and a complaint was registered by the excise department. Now, pursuant to this complaint, the charge sheet was also filed. Now, we challenge the entire proceeding before this court. And this court has granted us, the time-to-time stay was granted. Your lordship will get this. This is all the order, from the initial order till up-to-date order. Initial stay was granted on 19/10/2022. And the interim order is continuing till 19th of this month. CRR 3921.
Yes.
Now, my lord, when the matter was taken up by the bench, the opposition was filed by the excise department. Then, for the first time, we came to know that pursuant to a notification issued by the central government, and there is a direction given to the state government to cancel all the license granted by the dealers in the year 2016-17. Kindly see from their opposition, I have annexed certain document, page 39. It starts from page 39. But this is their affidavit. But relevant is, your lordship.
This affidavit filed in the criminal court?
Yes, before the criminal court, by the excise department, page 39.
Yes.
Now, your lordship will find the page 39 onwards, and kindly turn to page 52. Well, at central government in the year 2016, 10th August 2016, a reminder was given. Right hand side, your lordship will find the reminder to the Chief Secretary, Government of West Bengal, that all the profit store license, it was cancelled by the central government. So, in view of this, the order, the Chief Secretary was requested to cancel all the license granted to the vendors. Well, got it?
Yes.
Now, kindly turn to next page, page 53. The order dated 21st of February 2017. Now, the Superintendent of Customs, Kolkata, it has addressed to the Additional Excise Commissioner, Narcotics Cell Excise Directorate, saying that the 18 poppy store license which was given to the dealers, that should be revoked.
Been cancelled.
Well, got it? That should be revoked. Now, your lordship will find page 54. The Excise Directorate issued a notification. My name is number 1. Petitioner's name. This was on 21st of March 2017.
Yes.
Along with 18 dealers, my name also transferred.
Yes.
And they are saying that in view of the notification given by the Government of India, we are cancelling your license. Now, your lordship will find.
It's not served to you.
My lord, nothing was served to me. And what is the procedure also, my lord? I shall come to the. Kindly see the document, page 55, which is under challenge. But we got this document from the way of affidavit on 16th of January 2017.
Yes.
They are saying this document was given to me in the year 16th of January 2017. Which is, they have annexed, which is an incomplete document. Still, as per them, this document was given to us 16th of January 2017. But whether this document actually was given to me or not, to that effect, no GD&T was produced before the criminal court. Never. Only they have supplied this document. Now, kindly come to the law, what the Bengal Excise says relating to the cancellation of license. Your lordship knows better than us. Anything, any act done by the Excise Department has to do in terms of the law. That is settled proposition of law. Now see 42 and 43. Although 42 is not relevant for us, still I want to read 42 and 43. 43 is relevant for us, 42 is not.
Yes.
Power to cancel or suspend license, permit or pass, subject to the such restriction as the state government may prescribe by rule made under section 82 and subsection 2 and clause I of the authority who granted any license, permit or pass under this act may cancel or suspend it if it is transferred or sublet the holder thereof without the permission of the said authority. This is not our case. If any tax or payable is holder there will be not duly paid. This is also not our case. In the event of any breach of holder thereof or by any of his servants or by anyone acting on his behalf with the express or implied permission or any other terms and condition thereof, or if the holder thereof convicted of the offense, but these are not our case. But I only read this, but in which circumstances they can cancel the license. Now my case will fall in 43. Kindly turn to page 43. Power to withdraw the license.
Yes.
Whenever the authority which granted the license, permit or pass under this act considered that the license, permit or pass should be withdrawn for any cause other than specified in 42. So my case is 42.
Connected to 42.
If may, subject to such restriction as the state government may prescribe by rule under 85, withdraw the license, permit or pass therefore on expiration of 15 days notice in writing of its intention to do so. This is number 1. 2. Forthwith without notice after recording its reason in waiting for doing so. 2. When a license, permit or pass is withdrawn under subsection 1, our case will subsection 1, there shall be a period to the holder of the license, permit or pass, as the case may be, the amount if deposited as a security or in advance as a fees in respect of the unexpired period. I mean that our case falls here, unexpired period, because they have taken it, of the license, permit or pass together with the compensation amount to the 15 days average fees payable in respect of the license, permit or pass calculated in the manner specified in subsection 3. Provided that where a license, permit and pass is withdrawn without notice, the amount of such compensation shall be twice the amount of such average fees. But either I will come 1 or 2. Now say 3. The amount of 15 days average fees referred to the subsection 2 shall be calculated in the following manner, that is to say, where the fees respect of the license, permit or pass has been fixed by auction, the amount of 15 days average fees shall bear the total amount of fees, so that fix the portion of the period of 15 days bears the total period of license, permit or pass, and in other cases the amount of 15 days average fees shall be the average of for 15 days of the fees actually paid in respect of the license, permit or pass during a period of 3 months or during actual period whichever is less, immediately preceding the withdrawal of the license, permit or pass. Yes. So, this procedure, admittedly, your lordship will find from their affidavit as well as the letter which has been given to us was not followed. But one of the other dealer, he also challenged the similar proceeding was initiated against him. Your lordship will find initially he filed a writ petition before this court. Your lordship will find the single bench order in page 108 where his application was dismissed. Page 108.
Yes.
Well, similar facts.
Yes.
Now this was dismissed. Against that order, the petitioner approached the division bench. 110, your lordship will get the order. Now, what is the observation of the division bench? Your lordship will get that in 112, second para, which cover my case also. Got it?
Yes.
We find the subject item is covered under the NDPS Act 1987 and a license were issued to the appellant ex facie in violation of the directive of the central government. The appellant's claim in course of hearing the compensation for being deprived of the said poppy straw is in spite of storing them with the proper license. We do not think the court can direct the compensation is given the facts of the case of the exercise of a jurisdiction of Article 226. In our opinion, however, the license fees which were paid by the appellant after 9th of February 2015 ought to be refunded to them, and we accordingly direct such refund to be made within a period of 4 weeks from the date of communication of the order. In the event the appellant wants to claim compensation, it should be open to them. Institute proper proceeding as may be permissible under the law. We do not find in the judgment or order from the enabler, but the direction for refund we have given should be complied with. So, my lord, I also want the similar kind of relief which has been given by the division bench. Admittedly, they have taken, my lord, the license fees.
So you are having the period of 23 days, 27 days.
Yes. And, my lord, whether they have, my lord, followed the due procedure of law when, my lord, they have cancelled my license or not. But kindly ask them to, my lord, bring it to your lordship's notice.
First, under the incident of 2020, writ petition is of 2025. 5 years.
Yes.
Well, the incident that happened, the confiscation, whatever has happened is in 2020.
22.
20. 20.
Okay.
Writ petition is 2025.
Okay.
So 5 years, I know there is no specific delay or point of limitation act, but the principles will always be applicable. Why so much delay? Now, second, the criminal case is pending before they have filed an application under 482. Now just for proposition of law, kindly see Bengal Excise Act 2 subsection 13.
Section
2 subsection 13. I'm handing over the book. This is a Bengal Excise Act. It would be better. This is the latest, so it will be better. 2 subsection 13. 2 subsection 13, Roman 2. Intoxicating drugs means any other intoxicating or narcotic substance or any fermenting agent which the state government may specify in this behalf by notification, such substance or agent not being narcotic drug or psychotropic substance as defined in section 2. So, whatever will be defined under the Narcotics Act, this will be covered. Now kindly see the Narcotics Act. Subject to that is also a poppy straw which has been confiscated. Is
no doubt it will come under the NDPS Act.
No doubt about it. The provision 2 Roman 18. Poppy straw. Yes, my lord. Poppy straw. Now, my lord, the permission to use this is under section 8. Kindly see.
In relation to
section 8, prohibition of certain operations.
Section 8 of NDPS?
Yes, my lord, NDPS.
Yes.
My lord, no person shall will be cultivate opium poppy or any cannabis plant.
Correct.
So poppy cannot be cultivated except except for medical or scientific purposes. Except for medical or scientific purpose. My lord, in 2012, the government made certain instruction under 74 capital A of the Act, saying, this has no medical use of poppy straw has no medical benefits. Therefore, it cannot be used. This was the instruction, madam.
This is of 2012.
Yes. This was of 2012. Ultimately, further, my lord, as my learned senior friend had shown, page 54, there was a further instruction in 2016 that is at page 52, which my learned friend showed that it cannot be used because it is not a medically beneficial. Now, my lord, would just kindly consider page 54. There is a cancellation of all the licenses. Page 54. And this import of poppy straw is also dictated under the Narcotics Act. 54, First is the petitioner's name, and the quantity was only 20 kg. Now, my lord, admitted position when he was caught, my lord, kindly see page 45 of our opposition. Page 45. And in the
your opposition?
Yes, madam, in the opposition, madam, it is annexed in the criminal code that has been used, madam, page 45, paragraph F.
Yes.
My lord, what was confiscated was in 2000 stock, it was only 2000 was only, my lord, 2017 it was 20 kg. Now in 2020, when it was confiscated, it was found to be 1794. My lord, once it was confiscated, when it was direction to be destroyed, then also, my lord, how did they bring this amount of, which is a subject matter of challenge before a court? My lord, kindly see, my lord, when pendency of this, they are trying to bring in issue to invite my lord's attention to things which is beyond, my lord, with deepest respect. Today a criminal proceeding is there. Section 42 will not apply. Excise license, because when it comes under the, it is dictated under the Narcotics Act, which is the central.
That is correct. So
Yes.
this code, without going into that,
My lord.
once you have cancelled, you are telling that the cancel.
Yes, my lord.
If you have cancelled, then you have to proceed, follow the procedure.
My lord, I bow down before.
Follow the procedure.
My lord, yes.
If you follow the procedure, no need to give the whatever. If
Well.
you not follow the procedure, the consequences follow.
Well, just two things, my lord. My lord, those judgments, my learned senior friend has shown, that is also of 2017. So they are, my lord, they have annexed, they have not said when they have come to know of these judgments. That is of 2017 judgments. My lord, the question today would be,
I think the judgment there is a
no, absolutely, my lord, but what they have come to know of, my lord, today is the question, my lord, a single order was passed cancelling 17 licenses in West Bengal, cancelling 17. One of them had approached.
You produce the document that this has been communicated to the petitioner matter and.
My second, my question is, when someone attends, my lord, what my lord, the division bench has also said, payback or refund the whatever the license fee you have taken.
Correct.
Question is, my lord, in 2018 afterwards, it was, as my learned senior friend, it was on a portal. So government, my lord, they never told him to deposit those things. If someone, my lord, deposits, someone wants to enrich the government revenue, my lord, who will stop? Because government doesn't have any access. My lord, portal, he had an access and he has deposited the money. Portal, my lord, portal, he has had access. But subject to correction, my lord, portal, he accessed, portal, he paid the money.
Why he did not stop the portal? Will the question?
Let's kindly come to the page 37.
Well.
When he came to know in 2017, it was communicated to the chief secretary, it could have been stopped then.
35 is
Yes.
the last one.
Well, I've seen, my lord, 1920, I've seen that. But my lord, question is renewal. My lord, kindly, my lord, kindly don't take me for saying this. Renewal will not revive a license which has been cancelled, my lord, pursuant to a central act. That central act has also come under the constitution. My lord, it sees the Narcotics Acts, it is under,
So
it is.
when your revisional application is, when the revisional application is pending.
Well, before quote number 22.
I am releasing, let it be heard by the same bench.
No, I hear, my lord, on a limited issue in terms of the division bench order. But whether, my lord, my license fee, my lord, that I will face. But whether I succeed or lose, that's a different issue. Then, my lord, the trial will go on. If I succeed, it will be quashed. Otherwise, the trial will be go on. But the question is this: when the central government is instructed you from 2017, you please do not, you cancel this license which has been given by you. But why they have taken the license fees till 2020?
And division
and I am facing the criminal proceeding.
Okay, if you are telling.
But I am facing the criminal proceeding only because of this.
My lord, we'll refund this. My lord, it cannot be a reason, my lord, that he was not aware. My lord, question, today, my lord, these issues in the writ petition and the criminal process are intertwined. My lord,
it's not.
My lord, I'm telling you, because this will be used as a defense.
No.
This will be used, my lord, that is his case. He has said that, my lord, kindly see the first order in the criminal process. He says the license was renewed. But that is now was defense. Kindly see the order of 19th
Of
October
course.
2022. His defense. Now he is trying to gain advantage on this.
I am not asking
No,
for
no, no.
any
Kindly
advantage.
see. Kindly see the first
My
order.
question before your lordship
19.
is,
It's
kindly see the order.
order. He has specifically relied that the municipalities allowed him to do the business. Now he says that as because he has been allowed, I was doing the business. I am feigning ignorance to a law. This is a deemed provision.
You will
Absolutely,
not follow the law. You
no,
only
no.
ask me to
No,
follow the
no,
law.
no, no. Question
You will
of
not
no,
follow
no.
the law.
I have followed the law.
What
For
law you have followed? Have you
section.
followed 43?
43 will not be applicable.
Yes, of course
43
it will be
will not be
applicable.
applicable. I'll satisfy that. Today the question is 43 will not be applicable because it is governed under the Narcotics Act. Narcotics Act only allowed when this is for medical purposes. Today the government of India has said medical purposes not be allowed used. But kindly see his first order.
No, that is in 2012.
12 minutes. It was 2012. It did not reach whatever happened.
You have withdrawn the license
2017,
2017.
and he was
So how
confiscated.
How it can be given effect?
But question is 2000. No, I'm not giving effect. From 2017, it's confiscation has taken place in 2020. So, after the cancellation, when there's a specific order, today he wants to shift the burden on us, saying that this. But today he annexes our order of 2017. He knows everything. Now, kindly appreciate this. 20 kg was in 2017. Now, how could he import, which has been prohibited under the law? How could he import those things?
Have you got the investigation in the charge sheet? Have you got where from?
All charge sheet I've been in the matter said charge sheet has been filed. They have challenged.
Show me any of the NDPS case all over India. Even a commercial full of truck you have seized. Have you apprehended any persons of the main culprit? In any of the case you show.
Asking me something, my lord, which my lord,
You are putting the question to how he got that. So it is the duty of the investigating officer how to take
my lord knows the system better than I do, so my lord, I cannot answer that. My lord knows the system, but today my lord would kindly, after 5 years, my lord could kindly consider what
I suggest, and what he has raised the objection. I am referring this matter along with this criminal revision application. You will succeed automatically. You will get this.
And my lord, I take the point of maintainability. Kindly keep the point of maintainability.
Already division bench.
The division bench has asked him to refund. Will refund.
Correct.
That exactly I want. I don't want anything else.
Will
But
refund.
I don't want.
You said that he's only asking
that.
the refund.
No. He has asked.
Asking the benefit of the.
No, I don't want any benefit. I'll face the criminal proceeding there. But I have no problem. I want the refund. He has admitted that. Let it be recorded.
Refund you this prayer is only for the
Only
refund.
No, my lord, there is alternative prayer. Can you see?
I'm not recording.
Then I have to take specific instruction on this. Well, no, I cannot put it from my
He
pocket.
himself is saying he's ready for the refund.
No.
Just now.
No.
Yes, he has said.
See, this court will not go into other facts. Only with regard to as per the division bench order, as per your act.
Yes.
Rightly or wrongly, the amount has gone to the account of the authority.
Someone does it deliberately. Someone.
Why you did not stop the portal from
Total
2017?
accessibility, there is no particular number or password is there. Anyone can access. That is the difficulty. Anyone can access. But we'll bring those things and Malo tag this.
That's why the government has online. Online you can do anything.
But that is what he is taking advantage of.
Online, see, this portal cannot be open unless and until the license.
Yes.
Given. All the portal cannot be open. Yes. All the portal is open with regard to some code.
I should not make any submission when I'm not aware of the exact fact about the working of the portal. My lord is right. My lord, kindly tag this with the criminal matter.
No, do not tag it. It's a short issue.
You take instruction with regard to now only
only the refund of the amount.
Only the refund of the amount. My lord, I'll take
take instruction. If you said, I will dispose. When you will come with that instruction?
Next Thursday. Next Friday, madam.
No. आगे कौन ना? अरे मंगल बुधवार any day at 2 p.m. your lordship can keep. Any day at 2 p.m.
3 p.m.
Come on 18.
18 at 3 p.m. then, madam. 3 p.m.
3 p.m. I consider.
2 p.m. Aryan side matters being taken.
No, I didn't. If 3 p.m. subject to my lord, 5 minutes it will take because I have to come with the instruction whether we are willing. It will take 5
minutes. I can't because my My original 2 p.m. are the
No,
already.
18th my lord 2 p.m. 18th.
I am fixing at 1 p.m. See, 18 को 1 p.m. में है क्या बाबू? 18 को 1 p.m. 18 नहीं है ना? 18th को. Learned counsel for the petitioner has concluded his argument. Full stop. Counsel for the respondent state has also argued the matter at length, but he pressed for time for taking instruction with regard to payment of compensation.
Payment of fine amount, not the compensation.
Refund amount.
Refund of the
We are license fee.
For compensation, we'll go before the appropriate forum.
With regard to refund of the amount. Refund of the amount. Let the matter appear.
18th of Thursday.
December at 1 p.m. Take instruction. So that the merit will not go.
And
without touching the merit, I am saying so. In the criminal case.
Item number 10. मीटर लगा दें.
I am for the petitioner, Lordship. Lordship, the affidavit of service.
Item 10.
Lordship.
Affidavit.
Lordship, handing over the affidavit of service.
Yes, who is appearing? You are
I pray
appearing.
for the state.
Yes, I've got the instruction.
Yes, well. Lordship.
Your instruction.
My lord, this matter is regarding a marriage registration of an Australian citizen with an Indian citizen. My lord, the West Bengal special marriage rules were not amended, so the registration could not be done. However, my lord, instructions were taken from the law department, and the petitioner was informed by a letter that they could register the marriage under section 16 of the Special Marriages Act. However, my lord, if my lord kindly sees page number 2 of the instructions, since the West Bengal Special Marriages Rule of 2010 was not amended, it cannot be registered in the portal. So, my lord, the intervention of my lords would be required for that. This petitioner has been facing this hurdle for a long time, Lordship.
So they're telling that you apply under the section 16.
Lordship, we tried. Exorbitant amount has been asked by the registrars. We lodged complaints. We visited the registrar's office. The petitioner has been mocked, saying that in the future a provision will come, and then you come back and register.
No. There is an instruction has come in on writing. They have stated that the act has not been amended with regard to registration. Now they intend that you apply under the section 16 of the 54 Act. Then it will be taken into consideration and we will do a
Section 16, like Lordship, no option in the online portal. And when the petitioner is approaching the registrars, they are saying that there is also a letter from the registrar saying that, Lordship, in page number, it is in page number 19, Lordship.
Page number?
19, Lordship. Annexure P3, Lordship. Refusal of your marriage registration by Sri Polash Nandi and Srimati Mukta Sarkar. The Lordship, the main content.
No marriage officer can be registered a marriage of the married couple when one of the parties of marriage
Is a foreigner. Lordship, there is the thing that only because of he being a foreigner.
That's why I think this present act has not been amended.
Lordship.
Correct. So now 54 Act, they are telling that they will invoke the section 16 of the 54 Act.
Lordship.
So your contention is that the 54 Act is not available in the online portal.
Lordship.
So it is not possible for you to apply under the as per online portal under the 16 of the
Lordship.
54 Act. So
Lordship.
it cannot be. So
Lordship.
that you take instruction. If you wanted to register under the 16, he will manually file an application under section 16.
Right.
If he file the application, whether it is possible, if it is possible,
Lordship.
time it will take. You come with the proper instruction. I will pass an order. Done it.
Lordship. Lordship.
Correct.
My lord. Lordship. Obliged.
The Petitioner has filed the present application being aggrieved with the decision taken by the Registrar General of Marriage, West Bengal, wherein it was informed to the petitioner that no marriage officer can register a marriage of a married couple when one parties to the marriage is a foreigner. The Learned Counsel appearing for the state has handed over a written instruction wherein it is mentioned that the law department allowed this case of marriage registration to be done through section 16 of the Special Marriage Act, 1954, close, full stop. Learned Counsel for the petitioner submits that the marriage registration is to be applied under the online portal, but in the online portal there is no option for apply of marriage registration under section 16 of the Special Marriage Act 1954. And as such, the petitioner is not able to apply for registration under the Act of 1954. In view of the above, the learned advocate appearing for the state is directed to take instruction from the authority whether if petitioner apply for marriage registration in a manually, the authority can register the marriage of the petitioner and how much time it will take. Let the said instruction be placed before this court by 22nd? By 22nd of December 2025. Please the matter on 22nd and under the same heading. Affidavit of service filed by the petitioner be kept with the report. Try to solve this all.
Yes, madam. Obliged.
Item number 11.
11, my lord, I am for the petitioner.
We are appearing for the municipality. And allow my learned junior to my lord.
The state, my lord, is also a necessary party. Anyway, my lord.
Who is for the petitioner? You?
I am for the petitioner.
The prayer.
But kindly sees, my lord, that a notice, my lord, under the Inland Fisheries Act that has been, my lord, sent to the petitioner, directing the petitioner to restore the land that has been, my lord, already classified as Vastu residential to pond, to water body. This is, my lord, that order I have challenged. This is now, my lord, the second round of litigation. The first phase, my lord, the matter was moved.
Have you obtained loan for the fishing?
No, not fishing at all. My lord, this is the, my lord, kindly sees, my lord, I'll just place. My lord, I purchased this plot of land in, my lord, 2019 May.
Correct.
Subsequently, my lord, kindly lordship takes up, firstly, my lord, page number 27 once. On 5th of July, my lord, the BLLRO sends this notice to my lord, the original vendors, to my vendors, stating that it appears from the field inspection reports that the concerned revenue inspector that such and such acre out of such and such acre of the above noted pukud has been filled up by you without permission of competent authority.
Okay.
Thus, you have violated the provisions of Section 4C of the West Bengal Land Reforms Act. You are hereby directed to restore the water body, that is pukud, to its original character within 7 days from the date of receipt of this letter. This is what, my lord, they write. After that, a reply is given, my lord. Kindly sees, my lord, page number 28 by my predecessor. My lord, my vendor. They state that this was never pukud. This has already been converted into Bastu. My lord, kindly takes up the second paragraph of the last paragraph of, my lord, page number 28. Kindly take note that we are in awe of the receipt of your above referred notice. We the undersigned humbly and respectfully submit to you that the concerned plot above mentioned being RS plot number such and such corresponding to LR plot number such and such was and is all along classified as Bastu and all along used as Bastu. Records in your office will verify the same. That is what, my lord, what the contention is. After that, my lord, kindly takes up. My letter is at page 30. I also write to the district magistrate that I have already purchased the said land. So whatever be the communication from now on should be made to me.
So the purchase of the said land, the said deed which has been registered.
My
In
lord.
the schedule of the property, what is mentioned about the nature of the land?
Bastu. Bastu. It was all along Bastu, my lord. This was never Pukur. Now, my lord, kindly take some, my lord. This is very important, my lord. Page 31. Office of the District Magistrate, my lord, writes to the District Land and Land Reforms Officer as well as to the Block Land and Land Reforms Officer.
Yes.
My lord, this is the hearing notice.
This is the hearing
This is the hearing notice, my lord. Kindly, my lord, take some, my lord, the next page. Page 32. 32 is, my lord, the relevant. My lord, the BLLRO writes that with reference to the above, this is to inform him and her that in pursuance of the prayer of Sri Ownership Sadhu and no scrutiny of the related facts, it transfers that LR plot number such and such appertaining to Mouja such and such is by classification Vastu, and therefore the notice issued by the memo under reference alleging filling up of pond is not maintainable and is therefore treated to be withdrawn. My lord, that means, my lord, they have already, this is their admission. After that, what, my lord, happens is I obtain a sanction plan for the said bill, for the said plot of land for constructing a business building, my lord, because I run a business of constructing buildings, and my lord, I'm a developer. Now, my lord, the difficulty starts at page 33.
Yes.
The Hugni Chishuda municipality, who is, my lord, in terms of the act, my lord, the executive officer is, my lord, the competent authority under section 17 of the act. He, my lord, gives a notice for restoration of the water body known as Pukur. In spite of the fact that they have already, my lord, provided a sanction plan for this plot of land. The municipality has provided a sanction plan. And now, my lord, the executive officer acting as the competent authority under section 17.
There is a sanction order.
Sanction plan, my lord, have craved, my lord,
Not disclose the sanction order.
sanction plan, sanction building plan. Plan, my lord, I have craved it, my lord. If your lordship, my lord, directs me, I'll produce the plan, my lord.
Okay.
This is an admitted fact, my lord. My lord, I challenge this. I come up before this honorable court, my lord. The order is at
You challenge this page 33.
Page 33, I have challenged, my lord, in the previous round of litigation.
Okay.
My lord, page 36 is the order. And my lord, I file a representation subsequent to this.
What the court says?
33, my lord, page 33, my lord, 36, my lord, the order starts. My lord, kindly takes up page 38.
Correct. The municipality will take thereafter the decision whether the person which means the petition is can be kept in abeyance.
And my lord, this honorable court, my lord, records that there is a discrepancy in identifying the proper position of the plot of land where the petitioner intends to rate construction.
That's why the court has given, na?
My lord.
If it appears,
Yes.
38 last line.
Last
if
line,
it
my
appears that there is any error in the record, then necessary steps shall be taken. To
Grateful,
rectify.
grateful, my lord.
Then
After this, my lord, they have passed the order. Kindly, my lord, takes up page 42.
42.
Starts at, my lord, page 42.
Yes.
May I take your lordship to page 40? My lord, the representation was also, my lord, by the
That I have taken. Yes.
there was representation of the, my lord, land and land reforms officer, my lord. Page 43 is there in the middle portion.
From the office record, building plan has already been sanctioned by this office in favor of the petitioner as land record without following other existing laws. Spot inspection were carried out by the petitioner.
Legal inspection will be approved also.
Yes.
Now, my lord, kindly considers the learned this honorable court, my lord, specifically holds, my lord, that there is some discrepancy with regard to the plot, with regard to the identification. Without going into that aspect, what they have done is, from the office record, it appears that a building plan has already been sanctioned in favor of the.
Yes, I've gone through.
My lord, this is what, my lord, this, in spite of, my lord, now, my lord, kindly considers, my lord, my predicament, my lord. I have already, my lord, obtained a sanction plan over this plot of land.
Let me hear.
After checking.
Well, kindly come to page 38, the order passed by in previous litigation.
38.
38. Fourth paragraph from top.
Yes.
There was an observation by the coordinate bench that to dispel any doubt from the minds of the parties, the executive officer of the Chinchura Hubli municipality is directed to conduct a spot inspection upon notice to the necessary parties, including the concerned fisheries officer, the block land and land reforms officer, and the petitioner to ascertain the exact place where the petitioner intends to raise construction. So this was the observation and finding of the coordinate bench. Accordingly, my lord, we serve notice to all parties. So upon physical inspection, we found otherwise. Kindly come to now the reasoned order, page 43.
Yes.
The column starts with representation made by the representative of Assistant Director of Fisheries, Hubli. May I read? Sri Shubham De, representative of Assistant Director of Fisheries, Hubli, state that if a land which retains water for a minimum period of 6 months in a year can be treated as water body, and the area of land of the petitioner is also 6 kata or 0.099 acre. From the spot inspection dated 3rd January 2022, District Fisheries Officer Training, Hubli, it appears that a water body measuring 7 kata may have been filled up, which is situated at Mauja So ward number 17 under this municipality. From the office record, it appears that a building plan has already been sanctioned by this office in favor of the petitioner. As the land record in respect of land is Bastu without following other existing laws, on 27th May 2023, a spot inspection was carried out by the technical team of this office, and at that time it physically appeared that a water body is filled up with hinge and bushes, and at the northern side of the said pond a guard wall exists. Guard wall is commonly used to protect the street or road which exists near the water body. On the date of spot inspection on 20 August 2024 and 6 September 2024, a water body is found which is fully covered with water weeds in respect of LR tag number 804 Mauja So and jail number 17 in the district of Hubli. Paper says it is Bastu, but upon physical inspection, it is otherwise.
No, that's why kindly come to the page 31.
30?
Page 38, sorry.
38.
Page 38, last paragraph. If it appears that if any error in the record, then the necessary steps shall be taken. So if your fisheries officer and a municipal authority found that it was a water body, but he has filled up for using of construction of the building or the property in question. Now, he has taken the two plea. He has taken the two benefits. One is with regard to the building plan, which the municipal authority have sanctioned. Second is the document, land record. Third is the sale deed. So all these documents containing that this is the Bastu land. Now your inspection report is otherwise. So the document has to be taken into consideration while considering in the judicial process. So that's why the court has given you liberty. If appear that if any error on the record, then necessary steps shall be taken. After this, okay, you conducted the inspection, you have taken the report of the fisheries department, you have served the copy to the whether you have applied for correction of the record.
That we have not done. It is not our duty, my lord.
No,
The
no,
court
kindly.
It
That's why I'm
appears there to be
asking.
error in the
That is the first. Unless and until today, suppose this is the courtroom, and tomorrow you will come, the courtroom is the water body. So it has to be proved. Who will prove? And document prove this is a courtroom. But as per your inspection report, no, it is not a courtroom, it is a water body. So which will prevail? Prevail by the document.
We are conducting an inquiry in terms of separate provision. That is Inland Fisheries Act.
I
Not in
appreciate, but
terms of land reforms act.
you may conduct the inquiry, But the document on the basis of which the person has invested crores of rupees or lakhs of rupees for purchase of property, what will be the effect of the default of the government? Of the default of the, and you, it is not your case that yes, he has purchased the sale deed by manipulating or in connivance with the revenue authority. When the municipal authority has found the the plan has not been sanctioned, you sanction the plan.
We have sanctioned.
That's why, unless and until this paragraph, last paragraph 38 cannot be compared with whether it can be said that the order impugned is in accordance with.
The plan was sanctioned relying on the sale deed and the record of right.
That's what I'm telling.
We speaks about
That's
the
why first I have given the 3 points. He is having the 3 points in his hand.
And when
And
we
you have brought now 2 points in your hand with regard to the physics department. Second is your inspection report. So report will prevail or the document of the government will prevail. And that too registered document. Which will prevail. That's why court bearing in mind has passed this 2-line has added in the order page 38. But you are not complied with.
At the same time, we are directed to cause for inspection over the site. That we have done.
That I am not disputing.
It's absolutely a water.
Court is not disputing. This is not wrong. This is not. He is also not disputing with regard to that. My only the question is that now the court has passed an order to do something. So you have to do something in terms of the direction passed by the court. So you have to comply.
Let us come back with proper instruction, madam.
What instruction? You know, your report does not say anything. So what instruction you will take?
Let us come back with proper instruction. Kindly give us 10 days time and we shall come back with
Kindly
further.
consider only one aspect. The construction was being made after obtaining the sanction.
Because
we have done it.
The construction, the inspection is being made after construction. There is already digging. There is already.
The coordinate bench found there was some anomaly. That is why we have been directed
That's
to
why the court.
Otherwise,
that's why the writ court sitting in the writ jurisdiction cannot decide whether the vastu it is the water body. It is the court has to ascertain from the document relied by the party. As per the document, 3 documents here relied upon. That's why the court has given you liberty, but you have not taken the benefit of that liberty.
But to that effect, we need specific instruction. Kindly give us 10 days time. We shall come back with.
The counsel for the petition has concluded his argument. Solicitor counsel for the respondent has argued the matter. But this court find that in the order dated, the coordinate bench by an order dated 13th of March 2024, while disposing of WPA 28119 of 2023, has categorically stated that, inverted comma, if it appears that there is any error in the records, comma, then necessary steps shall be taken to rectify the same, inverted comma books. The respondent authorities have not shown any document in the present date application whether the authorities have taken the recourse of the order as mentioned above. Learned counsel for the respondents prays for time for taking instruction. According case is adjourned. Let the matter appear on 22nd,
26th.
Under the same matter.
22nd.
Affidavit of service filed by the petitioner be kept with the record.
In relation to R12, that is not correct, Your Lordship. 992 volume 7, that is there.
Page number?
992 of volume 7. That is all. And the loan is earmarked as an SME loan at 544B. Sorry, I.
Okay, okay. That's why I have not kept for the wedding. Otherwise, all volume will be. So that's why junior telling him senior humble. Why senior? Why you are not arguing? For extension the same.
He's passed judicial order or mandate order. He takes us after this 2 weeks. He will not do that. He will only say your lordship has forgotten. He has forgotten everything.
See. The matter is listed as to be mentioned for extension of the interim order. The interim order is extended till 15th of January 2020. 15th January 2026. Why? Is extended till 24th of February 2025 or until further order, whichever is earlier. Whichever is earlier. Yes, call. Yes. Yes. Ah. Correct. 3rd January 2001. Now it is under challenge the 3rd January 2001. Correct. Use microphone. Use microphone. So as per as yes. That's why she's in the government panel. Yes. No, how many petitioners are here? 5. There are 5 petitioners. Yeah, petition number 1 is? Yes. Petition number 1 is the neighbor. Petition number 2 is the wife of the deceased. Yes. Father-in-law's house. Correct. What's the name? Panchanangan, yes. From bottom? Yes. Yes. Okay, then okay, you can take note. I will come to you. Let's see complete. I will come. You take note of it. What is mentioned. Yes, yes.
I was classified their house. I didn't get a feel for her mother after some time I saw Gori going towards the direction where I also went to the direction her mother also the Lord is on to the then up to a lobby. Can you from this and that was a serious concern. And my heart is so that is the only I think that was outside borrowing was uninteresting.
Yes.
What is there is natural cause between the why there are some
Yes. Correct. Next. Next, which one witness?
All similar.
All similar.
But now I want to make out in the open make out in the we have we are giving out number 4, paragraph number 4.
Yes.
When you have paragraph after that, here after that, one side. On the that is the order or after as per the court
Yes. Yes. Next.
There are how to decide it. There is nothing happened. Angular means more than law. There is nothing particular activity there.
Yes.
But is that diagram 9?
Yes. Which judgment you are referring?
Diagram 9.
Which judgment you are referring? Which judgment? Prakash Babu, yes. Hmm. Yes. 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 That is settled law. So how the case has been initiated? No, how the case first FIR 156.3. Okay. So if 156.3, so first is the UD case has been registered. It is the case of hanging. The first the unnatural case has been registered. During the unnatural case, the investigation was carried out. Have the investigating officer collected the investigation report of the UD case? Because all the things will be in the UD case regarding the Caesar postmortem and all these things will be in the UD case only. Correct. Part of the, but what about the UD case? What has done? Because it might have been submitted to the London judicial magistrate, sub-divisional magistrate under PM report hanging. That is not, this is not the case. Yes, it is hanging. Who is the de facto complainant? Who has filed the application under 156.3? Who has filed the application under 156.3? Father of the deceased. That's why. Father of the deceased, the accused number 3, petition number 3. Father of the God-in-law, father-in-law. No, that is the father-in-law. Opposite party number 2. Hari Krishna Manna. ये लोअर कोर्ट रिकॉर्ड आया है क्या? लोअर कोर्ट रिकॉर्ड अच्छे क्या? लोअर कोर्ट रिकॉर्ड, ट्रायल कोर्ट रिकॉर्ड, case diary is there. Yes, anything further? That's all. All petitions are available. All these accused persons are available. So you will get the benefit of that. That you will get the 35 years has passed. 35 years after this revision application came before this court for hearing. What mental? You got the admission. This revisional application admitted and got the stay and enjoying that 35 years. Once the 2017, if the case has been dismissed, why the trial court has not started the proceeded with the matter?
There was no stay.
That's why. No stay. So they are appearing before the trial court.
I could somehow get a copy of the picture. We cannot trace it. That is why I asked them to tell me whether they are surrendered or not. What happened after this because of my house. I was worried for me to transfer. They were like, what happened after that?
No. That is different thing. First we have to say what is the stage before the trial court. What is the stage before the trial court? You are appearing for the accused persons. Conta is a 2-hour journey. You can't go there. You can call the client for taking instruction. How you are appearing without material instruction? Judicates was
All these statements are never statements that what's the relation with one is the present house or the exit because on that day training of government and he went there he saw all of them together laughing he came back. That is it. All the ever statements they are stated that is all.
huh? No, I court you moved, but whether there is an stay, there is a stay. Can't be. What you are telling? You got, see 19th February 2001. There shall be a stay of the further proceeding in the court below for a further 6 weeks. Thereafter, not action, no extension. And state is also not taken any steps. That too. That subsequently. The present revisional application filed by the petitioners challenging the order of cognizance taken by the learned. Which court? Learned session judge, additional session judge. Where is the impugn order? By the learned Which court the cognizance was taken? ACGM contact. Where is the order? Where is the order? Which page number? Page number? Where is the court name? Where is the court name? Now top is also not there. क्या बोला? This is the petitioners have filed the present application under section 401 read with section 482 of Code of Criminal Procedure, praying for quashing of the proceeding of GR case number 508/89 arising out of PS Contype PS case number 180/89 dated 16th June 1989 under section 306 of the IPC and the order dated 30 January 2001 passed by the London Subdivision Judicial Magistrate Contai by taking cognizance of the offence under section 306/34 of the IPC. Full stop. The counsel for the petitioner has concluded the argument. Full stop. This court find that initially by an order dated by an order dated 19th February 2001, the further proceedings of the above case was stayed for a period of 6 weeks with effect from 19th February 2000. Thereafter, the order was not extended. The order of stay was not extended, and on 7th January 2019, the revision application was dismissed and the stay was vacated. Subsequently, by an order dated 4th of October 2024, 4th of October 2024, the application for restoration of the CRR was allowed, and CRR number 293 of 2001 is restored in its original file. Counsel for the petition has concluded the argument. Full stop. This court find that for adjudication of the revision application, trial court report is necessary, and this court also intend to ascertain what is the stage of trial, as since the stay was only for the period of six weeks, only for 6 weeks, and thereafter the stay was not extended. Let the trial court is there. Where it is pending, you are also not knowing. The London Court of ACJM Contai is directed to transmit the original case record of GR case number 508 up to 1989 arising out of Contai PS case number 180 of 89 dated 16/6/1989 under section 306 of the 34 of the IPC by the next date fixed, along with the report with regard to the status of the case. With regard to the status of the case and the status of the accused person. Let the report be, let the trial court record along with the report of the learned magistrate be filed before this court. I don't think before vacation it will be. कोई डेट है देखो 7-8 तारीख कोई टाइम पे है कौन सा डेट नहीं है वो बताओ उनको 6 तारीख फाका है 6th of January 2026 at 2 p.m. At 2 p.m. The office is directed to communicate this order to the learned magistrate for compliance. The written argument filed by the petitioners be kept with the record. Written argument along with the written argument and the translated copy of the translated copy of the statement of the witnesses recorded under section 161 of the CPC and CRPC be kept with the record. Next. No. Yes.
After which the matter was adjourned at the instance of the prayer of the respondent number 2 month. Bank. That matter was claiming compensation on the insurance policy which was forwarded by Cyclone Bank for the loss suffered by the petitioner was due to the bank.
Yes.
If my lord turns to page 21 of my read petition, this is the insurance policy starts at page 19. The policy covers the agent syndicate bank, now Canara Bank, my lord. Now after merger, it's Canara Bank, syndicate bank. If my lord turns to page 21 of my read petition, the last portion, impact of damage over that, my lord, the insurance covers, the policy covers the storm, cyclone, typhoon, tempest, hurricane, tornado, flood, inundation.
Yes. Next, what is your case?
And the case is for the fault of the bank. And it was not the incident was occurred and it was intimated by the petitioner before the bank, my lord. And it's at page 29. Next, the P2 is my 29. Intimation was given to the bank. The bank did not take up any step, and thereafter, if my lord turns to page 32.
So what you want from this court?
From this court, my lord, the sufferance which has been suffered by the petitioner, the loss suffered, has to be for a compensation, my lord. For the loss of the bank, today I am out of state. The entire, since I have failed to pay the dues of the bank to the loss, SRTC action has been taken by business.
How this court can decide your compensation?
My lord, if my lord turns to page 32 once.
Correct.
Annex P5.
Yes.
My lord, the loss has been admitted.
32.
37. Sorry, my lord.
37.
37.
Yes.
Is the letter issued by the bank to the insurance company. My lord, I bring to your kind notice that we purchased the stock insurance policy for fire and burglary bearing number such and such in favor of Rohan Bank, the petitioner. The proprietorship concern of the petitioner, covering the stocks of the tank. Unfortunately, the entire stocks were damaged due to Amphan cyclone on such and such day. The matter of loss was reported to us later on, and our representative visited the affected place and inspected the damages at that time, where there was lockdown. We are operating with a minimum strength and few from office side. Due to amid pandemic situation, we are unable to communicate the said loss to you with stipulated time. Which is an admitted position that the petitioner had intimated the bank, the agent,
The bank is the agent over here.
Correct.
Bank is the agent. Bank, it was intimated to the bank.
Ah.
But thereafter, it was their duty to get back the insurance, the insurance from the bank, so that I could not, for not communicating this to the bank, by not communicating to the insurance company by the bank, I have suffered loss. And entire DRT proceedings, my business has suffered. Privacy action has been initiated. My property has been sold. I am in streets now.
Yes.
The fault of the bank.
Okay. Yes.
Even
Let-
after the,
I'm appeal-
after the privacy action,
Mm.
I got chance. So the
Mm.
new policy has been started. It starts at page 39, Annex P8. And it is being the insurance money, everything, premium is being deducted from my loan account. They have started. They have the knowledge there was a policy. Today they cannot say that I don't have a policy. It is covered under page 39, Annex P8. And the DRT proceedings have been even started, initiated. Section 17 has been filed by the petitioner. Said,
So what has happened to the DRT proceeding?
it has been stayed, my lord. It has been
By
stayed.
this court?
By the DRT court. By the DRT court.
Yes.
DRT court. Since the 30 days notice was not served and the sale was taking place on the 29th.
Milord, I am appearing on behalf of Canara Bank, Milord. Milord, first the maintainability. I am just raising the maintainability of the writ petition, Milord. Kindly see the first prayer of the petitioner, Milord. Milord, 52 lakhs are writ in the nature of mandamus directing the respondent number 1 to forthwith pay compensation to the tune of rupees 52 lakhs
Correct.
to the petitioner.
Correct.
Milord, what we have done is we have only advanced the money, Milord, which was secured. The insurance was taken for their stocks with the United India Insurance, Milord. The respondent number 3. Milord, we have advanced our money. We have even forwarded what they requested to us. They are saying that probably, Milord, the bank is the agent of the United India Insurance. They had a separate contract with the United India Insurance, Milord. They had to take up the matter with the, Milord, what I understand, probably the insurance company has said that probably they have not intimated the insurance company within the time-bound manner. Milord, before the writ court, Honorable writ court, Milord, they are asking for compensation of an amount of rupees 52 lakhs, Milord. Milord, bank is in no way in fault, Milord.
Okay. My lord, I appear for the insurance company, my lord. My lord, from the grounds your lordship will see that there is no deficiency made out against the insurance company. And the prayer also has been sought from the bank, my lord. Now, just for your lordship's assistance, my lord, may I take your lordship to page 31, the repudiation letter, my lord. May I place this, my lord?
Yes.
With reliance to your letter dated 11/3/2021, received by our micro office, Kurgachi, on 22/3/2021, regarding intimation of your claim due to Amphan, which was held on 25/2020. In this connection, we are sorry to inform you that we cannot entertain the claim on account of violation of policy condition number 6, where it has been clearly mentioned that on happening of any loss or damage, the insured shall forthwith give notice hereof to the company and shall within 15 days after the loss or damage or such further time as the company may in writing allow in that behalf deliver to the company. Now, my lord, may I take your lordship to the clause, my lord, page 25. Yes. Your lordship will see clause 6, my lord. 6(1). Yes. On the happening of any loss or damage, the insured shall forthwith give notice thereof to the company and shall within 15 days after the loss or damage or such further time as the company may in writing allows in that behalf deliver to the company. Now, my lord, this loss was intimated to the insurance company after 10 months of the loss, my lord. So we repudiated, my lord. And that is why the writ petitioner here has not claimed any deficiency on behalf of the insurance company. Neither any compensation has been sought from the insurance company, my lord.
So how the 52 lakhs against the bank this writ court can decide, sir? 114.
111 is my lord.
Hmm. Hmm.
And 2021, now you file in 2025 after 4 years.
2025.
Yes.
Then.
Then,
But the loss,
Hmm.
but the loss has been suffered for the wrongful act of the bank only.
Hmm.
Then admitted that they have admitted that thing. But
Hmm.
net profit the petitioner would ask,
Hmm.
then has been calculated and certified by a chartered accountant. It might have comes to page 111 there.
yes, yes, I gone through. Yes. Anything further?
Okay.
The petitioner has filed the present writ application praying for a mandamus directing the respondent number 1, that is the Canara Bank, Kamarhati, Prabartak Jute Mill branch, for payment of compensation to the tune of rupees 52 lakhs. 52 lakhs. Counsel for the petition submitted. The petitioner has obtained financial assistance from the bank and also insured the materials purchased by the petitioner for the purpose of the business of the petitioner. Due to the attack of Amphan on 20th May 2020, the entire stock of the petitioner, total value of rupees 11 lakhs, lying in the shop of the petitioner was got damaged due to heavy rainfall and water loss. Police stop. The petitioner submitted that the same was intimated by the petitioner to the Konkan Bank on 21st of May 2020. But the bank failed to inform the insurance company. The petitioner has relied upon. Where is the letter of the bank intimated? Relied upon the communications made by the bank, Canara Bank, to the insurance company, wherein the bank has admitted that the petitioner has sustained damage due to the Amphan, but due to the lockdown, the bank could not intimate the same to the insurance company with regard to the insurance claim of the petitioner and requested the insurance company for taking leniency and for release of the claim of the petitioner in terms of the insurance claim. Counsel for the petitioner submitted due to the delay on the part of the bank, the petitioner could not get the benefit of the insurance claim of the damaged stock of the petitioner. Learned counsel for the respondent bank submit that the petitioner has filed the present application claiming rupees 52 lakhs from the bank, but the petitioner has not disclosed any document how the compensation of rupees 52 lakhs can be ascertained by this court in a writ proceeding. Counsel for the bank further submit that it is admitted that the petitioner had the insurance policy with regard to the stock and the said stocks have been damaged due to the Amphan cyclone But the petitioner had the duty to inform the same to the insurance company for getting the insurance claim. But the petitioner failed to inform the same to the insurance company for getting the claim in terms of the insurance policy. And thus said the bank is not liable to pay the compensation as claimed by the petitioner. Learned counsel appearing for the insurance company submit that though the petitioner has had the insurance policy with regard to the stock which he has purchased after obtaining loan from the bank, but the petitioner failed to inform the insurance company with regard to the damage. The petitioner has only informed to the insurance company after the period of 10 months. The insurance company has relied upon the standard fire and special peril policy perils policy, wherein it is categorically mentioned that on the happening of any loss or damage, the insured shall forthwith give notice thereof to the company and shall within 15 days after the loss or damage, or such further time as the company may in writing allow in that behalf, delivered to the company. Not come across. The advocate appearing for the insurance company submit that the petitioner has not intimated to the bank with regard to the said damage within the specified period, and after the period of 10 months, the petitioner has informed the same, and thus said the insurance company has not considered them. We further submit that in the present date application, the petitioner has not made any claim against the insurance company. Against the insurance company. But the learned counsel for the respective parties produce the materials on this. This could find that the petitioner has obtained loan from the Canada Bank and the material purchased by the petitioner has been insured by an insurance policy. But due to unfortunate uncyclone, the materials of the petitioner got damaged. But the petitioner has not informed to the insurance company within a specified period. The petitioner has blamed the bank that the bank has not intimated to the insurance company. And let's say the petitioner has claimed the compensation from the bank instead of the insurance company. Considering the above, this court find that the petitioner this court in a writ jurisdiction cannot decide with regard to the compensation as claimed by the petitioner against the bank. According, the writ petition is dismissed. However, the dismissal of the writ petition will not prevent the petitioner for taking appropriate step before the appropriate court. WP. Next, dismissed. Yes.
Your Lordship, I inform respondent number 1 in this matter for Union of India.
My appearing for the state respondent, Lordship.
Lordship, they are appearing for the Union of India.
Union of India.
I am also there for Union of India in this matter.
The job has been done, what you need to think. Okay, I am really on that. State government should come for a will, they are going to take.
Yes. Lordship, because this scheme has sponsored by the central government, we are not provided any funds, Lordship. That's why this delay, Lordship. We are ready to pay, subject to the payment from the central government.
Lordship, we have sought instructions from the department regarding this. Yes, yet we are ready to see instructions. Kindly give
When you receive the writ petition? When you receive the writ petition?
Lordship, we have
October.
Lordship, we have communicated them regarding the instructions. Kindly give us 3 weeks time.
3 weeks for instruction.
Lordship, we have communicated twice to them. Kindly provide.
Okay, if you communicated, they are not responding. I am passing an order. You release the amount. You sanction the amount. When the amount will come to the state government, the
Lordship,
state government will release the.
We will pay. We
And
will pay.
nothing else.
Can you provide some?
Simple procedure.
Lordship,
So
we have
because the Union of India is not hearing you, not giving the instruction to you. So what can we do?
Can you provide 2 weeks time?
Mangera, the people,
I
poor peoples.
Can you provide us some time?
Give us 2 weeks time, your lordship, as this year she is writing till.
Correct.
We'll come up with the
I am
with the
giving
right
1 week. I am
right
fixing.
direction.
Today we are on 12th. I am fixing on 22nd. I am fixing on 22nd as a
Lordship,
urgent
pardon,
matter.
please
Take
give us
instruction.
some more
I
time.
am also opening on my mind. If you not take instruction, I will pass an order directing you to sanction the amount within a specified period, and after getting the amount, they will release the amount.
Lordship,
This
my humble prayer
format
is that
order.
give us
Please
some
inform your
space.
authority also.
At least 2 weeks time, your lordship, so that we can come up with the right
Learned
instruction.
Council appearing for the Union of India prays for time for taking instruction. Accordingly, case is adjourned that the matter appear on 22nd December under the heading adjournment.
22nd September.
Affidavit of service filed by the petitioner be kept with the record.
22nd.
Your lordship, may I
Please,
request
you
my
mention
name
yesterday
may be
matter,
recorded in
but
the
I
chat
signed
box.
that. You mention on Monday, I will take this. This is the matter. Okay.
Lordship, my presence may be kindly be
I
recorded
thought
in
the
the
other
chat.
matter. Okay.
Dada.
My lord, here I am for the state respondent, my lord. Kindly adjourn this matter because Supriya Chattopadhyay, landed AGP, is taking breathing problem, my lord.
Yes, on the last occasion also taken adjournment. Which order? Where is the order? Page number? When your senior will be available?
Monday, my lord.
Monday? Till Monday not to.
And as for the respondent number 4, my lord, I prefer not today, my lord. Due to the payment of advocate on record, my lord, has not come to my lord. Kindly bring it on Monday, my lord.
Okay, come on Monday. Yes. As per the prayer made by the council for the respondents, case is adjourned. Let the matter appear on Monday under the same heading. Monday means 15th. Come on Monday. There is a 2 days that there is a holiday. Please make sure you have taken the adjournment. I am fixing with these 2 days not to pass any order directing to deposit the money. Otherwise, I'll pass a proof. Recorder. This court hope and trust. This court hope and trust that in the meantime the respondents will not compel the petitioner to deposit the fee. Deposit the money in terms of the notice dated. Order dated 10/11/2025. Next. Yes.
Well, I am for the added respondent CAC.
I vote. I say that I beg to defer with you. Kindly, I will bring that.
My lord, I appear for the applicants, my lord. This is my affidavit of service.
Applicants? Okay, let me see. Rule? Rule 4. Yes. Where from you are reading? Rule 4? Rule 4 is a restriction of activities of the wetland. Huh? The first is the Hindi portion, second is the English portion. Yes. Rule 5 is the wetland authorities. Wetland authorities, then all the things A, B, till Q, P.
Then come 3 and 4.
Page 11. Yes, 4, yes.
4
Yes.
Regulation under these rules. Now, can come to rule 7. Rule 7, Act 13, all regulations of the government for evaluation and application of the wetland was all for the after side. Now, let's for that. For the issue is divided. Because the kind of place why internal side.
Yes.
And also internal side. So these figures have been checked out. The wetland under the management group 17 and the guidelines thereafter prescribe the next step after identity. Some wetland is what is called ground. It is the term with the actual policy of the state for that purpose. State has always been aggressive by all states, except for the Punjab community. And because evacuation is wetland of state has come for something up. So the general development and come to other they have kind of particular what is the rules follow.
Yes. Yes.
Then you can come to internal place 10.
Yes.
There are now that are now in the evaluation of the wetland boundaries the next step. As for the actually comes from therefore guarantee how to see as well as demands of wetland how this topic. I think step by step agriculture at last. Now the can come to last page. After 70. The register of all I had to above the hypos are the electricity as super bounding where appointed practice the code and ensure that the officer side are only my understanding is that by these guidelines or hypos to pay the proper measure on the one side under the 70 rules. But to my side, like the alphabetics of the state of those things. So these guys cannot answer this issue.
Correct.
This is why they can know.
No, yet the High Court, the Supreme Court said High Court are requested to treat the affidavit as suo motu public into litigation. We are an application. Okay.
Pending cases, but have done the violation of that, you know, I have to be other.
It is pending here.
No, pending to now, I got whatever what these are matters pending to the High Court on this issue. I agree with your matter. I have done the medical act that article to be otherwise than technically the other that.
So what you want now?
No, I don't say
I am releasing it.
This one cannot actually the issue. Really, why is that? His make is confined to one color and stuff. Only the upper maintenance of the other side and to the rules. And then to the fix act. You are going to fix things that I value of a matter.
Yes. That is different thing. Have you served? Yes. Yes. So I don't know whether this matter is pending before which court. Different court. Ah. So that's why whether it is if all the matters, then all matter is to be taken. So, but how this court can, unless until all the but the petitions are not here coming before this court. So you are the petitioner. So you the issue notice to all. So you issue notice to all. So if you are the petitioner in all the cases, let issue notice to all the respondents. Let come and I will fix. I will bring this all the writ petition along with your writ petition and matter be, and in the meantime his application will be taken up for hearing. Yes. So counsel for the petitioner has handed over the pending writ petitions connected with the similar issues. In view of the above, the petition is directed to issue notice to all the respondents with regard to the different writ petitions which involve the similar issues. Let the matter appear on 23rd of December 2025 along with this matter. Okay? Let the matter appear on 23rd of December. 23rd December. Because your stay is till 23rd. That's why I kept on. Under the same heading.
My application will be.
Let all the come then.
Your support access has been.
Well, all these writ petition will come together.
On that day, you issue the notice. If all petitions will come, and I will pass an order for bringing the all documents. Because today the all respondents are not here.
And in those matters, Your Lordship, if other respondents required to be implicated.
Correct.
KMC state electricity.
That's why I have already passed, issued the notice. I am fixing this matter on 23rd.
I'm grateful, man.
I'm grateful to you.
Yes. हटाते भी नहीं यही हो गई Yes.
But it's the date for issuance of a passport. You file the application and the passport has not yet been issued. Any day prior to the issue, 1 day for nothing to convert. The festivities around, maybe passport becomes more eligible.
164.
Yes, ma'am, any day.
Have you issued a notice to the SDI? No, because they will come, then they will say they have no instruction.
They are not there on Monday. That also they said that they are not there on Monday.
कब रखेगा?
Any day.
कब रखेगा? Tuesday on top. Yes, next.
My lord, may I be permitted to mention the interim order is expiring on 17th. The matter is appearing in my lord's list today at item number 141.
So, रख दो 17.
My learned senior friend is here.
When you are going to be expired?
17th.
17 is
Today's 12th, my lord. 17th.
16 को 2 भी mention में कर दो.
Grateful, lord.
Extension of interim order. Yes. Call the list.
Lordship, I appear for the respondent number 3, defendant number 3.
Who is for the defendant other?
First defendant, Mr. Das is appearing, my lord. Only thing, my lord, there's one correction that has to go. My lord, I mentioned I mentioned the matter, my lord. First defendant has not filed written statement, but the bank, who's the second defendant, they have filed a written statement. My lord. That has to be corrected, my lord. The recording is incorrect, my lord. That has to be corrected, my lord.
Way back in 2022.
22 they have filed.
ऑर्डर नहीं लगा है क्या?
हाँ.
ठीक है आपने वो बोले थे कागज जाने.
Yes. So defendant number 4 has filed.
No, my lord, is defendant number 3.
3 has filed.
And my lord, my name should be deleted because there were 2 loan accounts, one with the plaintiff and one with the defendant number 1. Both the 2 loan accounts have been settled and closed. So there is no privity of contract between the plaintiff either or the defendant. So my name should be deleted from this. I have been.
You will be benefited. Let the.
No, I'm not. My client is getting worried about every day this type of order is being passed. So one day.
You do one thing for the material instruction. File 2-line application.
Well, that I will.
You will be benefited further.
That application করে আমাকে একটা copy দে.
So defendant number 1 and 2 not filed.
No, 2 is the State Bank of India.
State Bank of India. They, 1 has not filed.
So the matter is listed and the matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. It is found that the defendant number 3 has already filed the written statement. 3 has already filed the written statement. But the defendant number 1 has not filed written statement. Writ of summons, when the writ of summons was served, you have a report.
Writ of summons was served long before, my lord.
You have a
Long.
writ of report.
Yes. Yes, we do. That রিপোর্টটা কোথায়?
The
The last page, Lordship will kindly.
petitioner has handed over the service report of the deputy service service report issued by the deputy service of Kolkata dated 22nd December 2022. Wherein it reveals that the writ of summons was served upon the defendant number 1. Second written statement is fine.
Lordship will kindly take the second paragraph of the report. It has been mentioned that on 28th of November 2022, my lord, the first defendant was served with a copy of the writ of summons. Yes, yes. I'm sorry, my lord. I'm sorry.
In view of the above, let the CS number 162 of 2022 be placed in the list of undependent against the dependent number 1. So what about they file the written statement? Then issue.
Well, I am for the defendant number 1. Whatever we got the transfer brief we got it recently, sometime in the month of August. We could not file our returns. We were not aware of the fact. Many documents also reach the learned advocate that even as for change over. Many documents are also missing. We are still searching upon writing letters to them. Kindly give us some application. This is my predicament.
What is your prayer?
It's in the independent field, but at least I get a chance to file my written statement. If at all. That is what
What the bank will do?
Not bank. I am for the dependent 1.
So you are not you are not file any application. Yes. बोले क्या बोला?
Application file.
Place in the list of undependent against the dependent number 1. Full stop. List the matter. Full stop. The document inspection completed? No.
Nothing.
The plaintiff and the defendant number 2 and 3 are directed to complete the discovery and inspection of the document within 3 weeks. Full stop. Affidavit of admission and denial of the document will be filed within a week thereafter. Full stop. List the matter. 3 weeks, 1 week, no 4 weeks. List the matter on हमारा ओरिजिनल साइट क्या है ना कब आएगा बुध को ना 7th of January 2026 for framing of it.
Grateful, my lord. In the meantime, my lord, we will exchange suggested issues, my lord, with the reference number.
In the meantime, the parties are also directed to exchange their suggested issues.
Grateful.
In the
May I
meantime,
take
the
back
parties
your-
are directed to access your report over there. Studies. Report. Yes, next.
But I am here for the alleged contemner number 1. My lord, I am appearing for the. My lord, I am led by my lord Ratnamko Banerjee. Please appearing.
I'm sorry, my lord. I'm there, my lord, virtually today. I'm so sorry.
My lord, let the affidavit of service, my lord, be kept on record.
My lord, with regard to there was an order of injunction, my lord, will recall with regard to my lord property, and they had my lord sold it.
We have received instructions to appear in this matter, my lord, very recently. I would beseech your lordship, my lord, to kindly fix it on a date. My lord, it's listed today under to be mentioned. My lord, we'll come back and we'll
Now, this is a content matter?
Yes,
Yes, my lord.
Content matter. Rule issued?
No, my lord, we want issuance of rules, my lord.
But if your lordship sees on the last occasion, your lordship felt that it was, my lord, necessary that the contemners be heard. Lordship would kindly see.
Lord, para 5 of the order of 25th July.
Even after the result
We have not been able to, my lord, file our vakalatnama as of yet. My lord, the department is not accepting it. Was also, my lord, beseeching your lordship to kindly grant us that liberty. We'll file our vakalatnama, my lord, in the department. My lord, we'll respond to their alleged, my lord, application for contempt.
Okay. How soon you will file affidavit?
Lordship would kindly give me, my lord, 3 weeks.
Yes, Mr.
My lord, a rule should be issued, my lord. They can only respond to the rule, my lord, or my lord, I don't know.
Appearing is
I am
appearing,
appearing,
one
my lord.
chance I am providing one chance. If they will not file the affidavit, then rule will be issued.
And my lord would
Very good. My lord, there's an
kindly-
interim order, my lord, that can continue, my lord. There's an interim order which was
On a very
passed.
cursory glance, my lord, what I can see is that they have pleaded my constituted attorney as an alleged contender. But there is no allegation of contempt made
Anyway,
against her in the entire.
either my learned friend wants to file an affidavit, or we can argue today also if he wants.
The point of maintainability open.
There, Mr. Banerjee, there's also the contempt number 2, which is the
Yes,
buyer.
yes.
The
My lord
buyer.
has seen that. My lord has seen.
So let the issue be rule be issued against the bank.
Yes.
Buyer, not bank. Buyer.
The buyer, my lord.
R2, respondent 2.
R2.
Yes, what is your submission, Mr. Sharma?
Well, we are all
My lord,
together.
Mr. Sharma is with me, my lord. He
We
just
all
wants to
together. I
make
could
his
not be there.
presence felt.
That is a bad habit. Once the senior is making submission, why you are making submission, making
No,
a
no.
confusion upon the court? Now,
I'm
last occasion also, Mr. Mukherjee has alert you.
Me?
Please,
I'm
Sharma,
sorry.
not to repeat this. At least before this court. Once the senior is appearing, though you are appearing, either take the leave from the senior and mention the
I followed.
Learned counsel for the alleged contemners. You are appearing for all contemners?
No, my lord, I am appearing only for the alleged contender number 1.
What about the 2 and 3?
My lord, I have filed the affidavit of service. It has been served, my lord. Maybe, my lord, the affidavits will be filed in installment. That is why they are not appearing today.
Not served.
But served, my lord. Both 2 and 3. My lord, the affidavit of service dated, my lord, 20th August. There are 2 sets of affidavit of service.
Learned counsel for the alleged contempt number 1. Pays for time to file affidavit in opposition. Let affidavit in opposition be filed within 3 weeks after serving the copy to the learned counsel for the petitioner.
Department of
Reply, if any, be filed within.
My lord, we will file within 10 days.
Within 10 days. Police. It is found that the alleged contempt number 2 and 3 have received the notice, but in spite of receipt of the notice, none appears on behalf of the alleged contempt number 2 and 3. Let the rule be issued against the alleged contempt number 2 and 3. Police petition is directed to take appropriate step for issuance of the rule and to file requisition to the department.
My lord, also, because para 5 of the last order, my lord, the interim order needs to be extended.
Within a week. Within a week from date.
My lord, I am kindly, my lord, pardons me, but I am instructed, my lord, we are appearing for 1 and 3. Not my lord.
Now they will.
Now kindly see, my lord. This is most unfair.
Then very
Most
well.
unfair.
Who are we appearing?
1.
Then very well. Then don't.
One.
Then,
Yes. Correct.
Let the matter appear. Let the matter appear on 3 weeks and 10 days. Let the matter appear on 20th January 2026. The interim order passed by this court dated 25th of July 2025 is extended till the next date of hearing.
Lord, kindly record, my lord, that the point of materiality of this application.
The counsel appearing for the alleged contempt number 1 raised the point of maintainability. Same is kept.
And Lord, would kindly also grant us liberty to file the wakalatnama in the department.
Highlight the counsel for the advocate on record of the alleged contempt number 1 is given liberty to file wakalatnama in the department within a week from date.
I'm grateful.
On behalf of the alleged contempt number 1. Yes, next.
Well, your lordship was hearing GA3. Well, GA3 is an application for, my lord, interim reliefs in a suit, my lord, for which, my lord, really the essential prayers are, my lord, for a declaration that the powers of attorney could not have been revoked, and, my lord, injunction restraining them from giving effect to the revocation of the power of attorney. Now, my lord, pending the disposal of, my lord, GA3, my learned friends have also filed an application, my lord, GA4, my lord, which in our respectful submission is beyond the scope of the suit altogether. My lord, we have to file our affidavit in J4, my lord, it is ready, we shall file it, my lord, within a day or two. Now, my lord, so far as J3 is concerned, my lord, lordship had heard my submissions initially, And then my learned friend has also made his submissions. I have to respond.
GA3 has been disposed of, no?
That's why I am thinking on that.
I'm sorry, GA1.
GA1.
No,
One is going.
Yes.
GA1.
One, we were supposed to give a notes of arguments we've prepared. Unhadir copy now.
Well, although I'm being served now, my lord, let me, my lord, proceed with my arguments. I'm ready, my lord, to argue now.
না, এটা তো হয়ে গেছে স্যার।
এটা কি GA1 হয়ে গেছে hearing? আমাদের তো reply দেন।
GA1 is complete, my lord. That is recorded in the order sheet, my lord. Last order.
My learned friend's argument is complete.
No,
My
if you-
learned friend's argument is
but-
no, I have to
I would
reply.
kindly see, my lord, what is there.
Well, with the leave of my learned leader, my lord, if your lordship permits me, I can just recollect for my leader, my lord.
Counsel for the plaintiffs already filed written notes of argument. Counsel for the defendant prays for time to file written notes of argument.
But
Yes, my
kindly
lord, we had initially filed written notes of arguments and
No.
then made submission.
31st November. Counsel for the plaintiff already filed the written notes of argument. Counsel for the defendant prays
And the
for
paragraph previous to that, my lord. Hearing concluded.
That's why hearing concluded, filing written notes of argument.
If your lordship permits me leave, my lord, with leave of my learned senior, may I make one submission, my lord? On the last occasion, my lord, we gave a reply to the other side's argument. Then on that date, they filed another application, GA4, to which, my lord, we have filed an affidavit in opposition, which is, however, nothing but a reproduction of their affidavit in opposition to GA1. So, my lord, we have used an affidavit in opposition to their application.
That is the GA4.
That is GA4.
Yes.
In fact,
GA1 is hearing concluded.
Well, very well, my lord. I shall not, my lord, trouble your lordship since it's recorded. But my lord, only thing is, my lord, in GA1, my lord, we had initially, my lord, made our submissions, to which my learned friends have now filed a written note. My lord, perhaps in the fitness of things, my lord, my written note was filed long back. My lord, perhaps in the fitness of things, my lord, I should also, my lord, assist your lordship by filing, my lord, a written note. My lord, most of it will be, my lord, compilation of judgments. My learned friend, of course, has, my lord, now annexed, my lord, a whole lot of documents which are perhaps not to be relied on.
We have not given any documents, sir.
I shall, my lord, file my notes with the affidavit in GA4. That's all.
So what is the GA4?
My lord, GA4 is my learned friend's application seeking interlocutory reliefs in my suit. Now, if your lordship sees the scope of GA4, my lord, please have a look at GA4 once.
But if
what
they
are
are
the reliefs?
But if they are filing an opposition, my lord, we should get a copy of that.
No, your lordship has asked me what is GA4. Well, I am responding to your lordship's question. Well, please have a look at the prayers in GA4.
Instead of all these things, let the appeal be clear. What is
Yes,
the
no,
state of the appeal?
No, my lord, the problem is, my lord, the appeal will decide, my lord, as to whether the trial of the suit should be stayed or not.
Correct.
That, my lord, so far as the trial of the suit is concerned, that has nothing to do with the interlocutory motions. My lord, that, my lord, is decided, my lord, by the Supreme Court and, my lord, by your lordship's court also. My lord, this is, my lord, authoritative pronouncement. My lord, there is no controversy about this. And that is why, my lord, the division bench said, my lord, even pending disposal of appeal as to whether, my lord, the trial of the suit should be stayed or not, interlocutory application can proceed. Now, my lord, my learned friends has essentially, my lord, taken, my lord, 2 points. One is, my lord, he says that, my lord, so far as the suit is concerned, my lord, the prayers in the interlocutory application, if granted, will dispose of the suit. Now, my lord, to that, my lord, our answer was twofold. First answer was, my lord, prayers in the plaint and the prayers in the injunction application are different. So, my lord, even if your lordship grants the reliefs in the injunction application, that will not, my lord, affect the final disposal of the suit. The second, my lord, submission was that, my lord, so far as the interlocutory orders are concerned, my lord, they are necessary to prevent prejudice. And, my lord, we had also cited authority to show to your lordship that, my lord, even when a question of maintainability is raised, my lord, even when there's a question of, my lord, maintainability with regard as to whether the suit should proceed or not, your lordship may pass interlocutory reliefs and, my lord, even, my lord, can grant interlocutory reliefs which are in the nature of final reliefs in exceptional circumstances, where lordship is satisfied that, my lord, without these reliefs, my lord, the suit will become infructuous. Well, what is our claim and contention here? Our claim and contention is, my lord, that there was a conveyance in 2003 by which a property was transferred to us. Along with the property, all, my lord, choses in action were also transferred. This was followed up by an agreement of 2010. that, my lord, confirmed the, my lord, transfer of the property and of the chosen action. And, my lord, further, my lord, said that yes, my lord, we should be allowed to operate a bank account of, my lord, the transferor company, because, my lord, the acquisition proceedings were started in the name of the transferor company, and so the compensation claims will come in the name of the transferor company. So, my lord, by a power of attorney, we were authorized to operate that account. Now, my lord, if today, my lord, the conveyance remains and the agreement remains, my lord, then the question is simply whether my learned friends can then revoke, my lord, this, my lord, power of attorney. For that, we had relied on section 202 of the Contract Act and said that, my lord, when a power is coupled with a grant of interest, it cannot be revoked. It becomes irrevocable. My lord, we had cited authority in support of that proposition also. My lord, now, my lord, so far as this is concerned, my learned friends now, my lord, come and say that no, we had, my lord, approached the city civil court for certain reliefs with regard to operation of the bank accounts. Now, my lord, 3 suits were filed. 2 suits by my learned friend dismissed. My lord, under Order 7, Rule 11. My learned friends have preferred an appeal. My lord, so far as the appeal is concerned, the appeals are pending, but my lord, the suits have not been revived. So far as one suit is concerned, that is 314, in that my learned friends had filed a counterclaim. Their counterclaim in the suit is rejected. What survives is only my suit, and in that, my lord, the only order that was passed is, my lord, to secure, my lord, my learned friend's claim of about 9 crores of rupees. Why 9 crores of rupees? Because, my lord, the court accepted the fact that although you may have been transferred the property and you have been transferred the chosen action in the property, well, ultimately, my lord, if today the money comes in the name of, my lord, the transferor company, then the transfer company will be liable to tax. Now, my lord, that matter, my lord, went up to the Supreme Court, came back, and, my lord, Supreme Court, my lord, directed security to be furnished. My lord, ultimately, my lord, the courts have accepted that, my lord, we have furnished, my lord, security by way of immovable property. My lord, that chapter is now closed. Now, my lord, my learned friends now, my lord, are raising the bogey that ultimately, my lord, if the appeals are, my lord, allowed, if my suits are revived, if, my lord, I succeed in the suits, then what will happen? Well, that is a question that your lordships will not, my lord, endeavor to answer at this stage, because the suits stand dismissed. And will stand dismissed for good reason, because, my lord, 2003 conveyance and 2010 agreement have been sought to be challenged, my lord, in 2024. So, my lord, clearly barred by limitation, my lord, court, my lord, dismiss the suits.
Okay.
My lord, this is, my lord, the sum and substance of the dispute. Now, my lord,
But GA4 which you have filed,
my lord, kindly see the relief.
contrary to the GA1. Kindly see the GA1 prayer A.
Well, GA1 is my application.
That's why GA1 is
Yes.
your. You want that you may be allowed.
That's
But
right.
they want, they may be allowed.
Correct. Now
and
you want the restraint.
We want the restraint.
Correct. So if the GA1 is disposed of, if
Yes.
GA1 is disposed of either this way or that way, so what would be the purpose of GA4?
But the purpose of GA4 is, Malad, there were 2 power of attorneys.
Correct.
Malad, this suit has been filed in respect of only the second power of attorney.
My lord, there are 2 suits.
That is 11th May.
That's right. 2 suits,
11th
2
May.
powers of attorney.
Malad, one is 11th May.
And 21st of November.
Yes. Malad, these are the 2 power of attorneys. Malad, both have been revoked. That is the position as per my client's submissions.
Correct.
Malad, under those circumstances, whether during pendency of the one suit, but even if we take one suit is pending filed by them before the city civil court, Malad, it has been my lord's view while disposing of GA3 that this suit should remain state.
Till that, yes.
Yes. Malad, the appeal court has granted an order. That portion of the order that should be stayed.
And
Malad,
injunction application.
yes.
My lord, with the greatest respect, in my suit.
No, that's no. My kindly come to the prayer A of the GA1 and prayer A of the GA4. Correct. GA1, 11th May is also involved as well as 21st November also.
Yes.
Right.
Now in this GA4, you are only prayed for the 21st of November.
Yes.
So that's why my contention is that if GA1 is disposed of either this way or that way or continue or
No,
not,
to some extent, yes, Malad. To some extent, yes.
then
Why
it
should I?
remains in the
Malad,
GA4.
the factual aspects, those are required to be considered by your lordship, Malad. Those are all there. Malad, what had happened, how they are trying to take away the money without the adjudication process being completed.
That is not the question, my lord, in the suit. My lord, today the law is very well settled.
But
I
the
will
other aspect is,
well, you
the-
cannot,
this
my lord,
power of
overwhelm,
attorney,
my lord, the prayers in the suit.
this is not coupled with interest. 202.
That's a good. That
Yes.
is their contents.
Yes, my lord, we would demonstrate
Coupled
that.
with the interest.
My lord, we would demonstrate that before your lordship, my lord, how, and they are relying on it. But we would show that to your lordship, my lord.
With
when
that,
our
my
turn
lord,
comes.
they've shown in GA1. What more will they show in GA4?
Would have been covered in the GA1.
But we were
It
expecting,
is already in the affidavit in opposition. In
but we were
GA1.
we were expecting an opposition. That is the order on the last occasion.
That's correct.
As per their prayer.
That's
But
correct.
if
Now-
they say we do not want to give an opposition, very well, we will
No,
contact.
no,
the-
I will give an opposition, but my lord, that should need not hold up the my lord, adjudication of
We are not
GA1.
holding up.
No, that's
But
why-
we are ready with the GA, what has been completed.
That's why this, if this court dispose of GA1, then again what remains?
Nothing
in the
remains.
But
Nothing
that was
remains.
the pleasure of my lord on the last occasion,
will be taken.
that both be taken. But it would hardly take 1 day's hearing to complete
My
everything.
lord, with the greatest of respect, with the
Lordship?
greatest of respect,
So one day, yes.
No, we would be very precise, my lord.
my lord, with the greatest of respect, my lord, GA1, your lordship is recorded hearing concluded. That is why, my lord, I have not, my lord, made further submissions.
No, but Mr. Sen was there. Mr.
Yes,
Sen
my
was-
lord, I will just, my
I
lord,
was there, sorry.
reconsider the notes, and if necessary, my lord, file a note by next week.
No, so how soon you will file the affidavit in?
My lord, that
GA4?
affidavit, my lord, I'll file by in 7 days. By next week, I'll file it.
So give the copy. So you file the reply. So this, I don't think the GA4 will take much
But
time.
my clients are based from Kerala, my lord.
Kerala.
No, this is the practical difficulty, my lord. They have to come to Kolkata to get it signed. But I cannot do it for them.
They can
Every
sign it,
time-
my lord. I think, my lord, there is a system of, my lord.
এখন আর হয় না এখন আর হয় না নোটারি দিয়ে হচ্ছে না
কে বললো?
Now that is stop.
No, that is stopped.
That is stop.
But every time they have to come.
After Corona is stop.
Yes. But every time they have to come, and they do come. Well, that is not a problem. But just that minimum bit of.
Well, let the affidavits, my lord, go in GA4. My lord, I shall, my lord, file my note by Monday. My lord, and your lordship will decide GA1. GA4, my lord, may take its own course.
Again, the court has to.
My lord, I don't think, my lord, your lordship need to concern your lordship, because if your lordship decides GA1 either way, as your lordship pointed out, then that will essentially decide GA4 also.
How soon you file the reply?
Within a week. No, within a fortnight, my lord.
No.
Fortnight.
But after getting that only, we can ask them to come.
I will file my affidavit by Monday.
Monday. So Monday you will get. Serve the our advance copy you can serve.
We'll serve, my lord.
Advance copy. Okay, Monday serve the copy. So Monday the fortnight, then it will be come. Then again after vacation. So you file by 2nd January.
But kindly makes it after 6th, my lord. 6th January is okay. 6th or 7th, my lord.
By reply. हम लोग को उसका बाद तो हमारा डेट भी नहीं है ना। हाँ? 9 जनवरी है 3 बजे। Okay, then I am fixing on 9th, but shortcut the matter so that the 9th the GA4 can be completed. I will fix on 9th at 3 p.m.
My lord, kindly just give me a moment.
See, Mr. Shah is having the date on 9th.
Well, my lord, might be in some. Can just give me one
But
more.
they should also serve their written notes beforehand, my lord.
No, I will give my written notes by Monday.
Monday they will file.
My lord, kindly keep it, my lord, on 12th then. My lord, 9th, my lord, I mean some.
কি হবে আমার কাগজ দেখলে ওর কি ক্ষতি হবে?
No, Mr. Shah will come.
12th one.
12th is holiday.
12th is a holiday.
Rather than 13th.
आगे कुछ है? 14 में कितना में? आधा घंटा में कुछ नहीं। पहले कुछ नहीं।
Well, kindly keep it according to lordship's convenience. If I am not there, Mr. Sen will be there.
14. 14. कब है? ना 9.
Very well, man. Keep it on the 9th.
Then at counsel for the plaintiff.
submitted. He will file the return notes of argument by
Monday.
in connection with GA1 of 2021 by Monday after serving the copy to Learned Counsel for the defect. Learned Counsel for the plaintiff. Further submit that he will file the affidavit in opposition in connection with GA4 of 2025 by
Well, by Monday also.
by Monday, serving the copy to Learned Counsel for the defendant. Defendants shall file the affidavit in opposition within 2 weeks thereafter. After serving the copy to the Learned Counsel for
The
the
2 weeks will fall within the vacation, my lord.
2 weeks thereafter. That's why I am fixing on 9th of January. So in the meantime, he will cover this.
Within
List the matter on 9th of January 2025 at 3 p.m. for hearing of GA4.
But we have filed our notes of arguments with regard to
Defendant has
GA1.
filed the plaintiff has filed the
Copy to notes.
sorry, defendant has filed the defendant has filed the written notes of argument. Let the same the recording connection
GA1.
with GA1.
Which petition?
3:30 minute we are ready. Both parties are here. My lord will.
Which petition? Kindly forgive me.
Yes.
One matter in the appellate side. This matter was heard by your lordship, appearing as item number 24 of the day. There's some
24 of the days is under which heading?
under urgent motion.
Urgent motion tomorrow, Monday it will come.
Monday may have some precedence. Issue is they are not awarding the work order. Your lordship desired a report. I shall inform them. May appear fairly at the top subject to your lordship convenience.
24.
Yes, 24. The appellate.
Appellate side is not here. 24 on Tuesday.
Monday answer.
Monday you are telling. Monday.
Saying Monday, if it can be reached in such a position.
Okay.
Unfortunately,
no, it will come.
Matters can
Okay.
have some precedence. 24.
Okay.
Milord, seeking out indulgence, Milord, item number 89 of the original side list, Milord. The petitioner of your lordship is 59 years old and going to be retired, Milord. The DO has issued a false notification for that my entire benefit has been stalled, Milord. But kindly give some precedence. 89 of original side list, Milord.
89.
Milord, today's original side list, Milord.
So what do you want?
Milord, any date prior to vacation, Milord. It's small matter, it will not take more than 5 minutes, Milord.
89 को देखो कुछ कर. 89. Yes.
Grateful to you.
May I?
Yes.
Milord, I.
Got the assurance that today will reach the conclusion.
No, this is assurance I can't, Milord. Yes, I appear for the defendant number 2 and 3 in this matter, Milord. And I will resume, Milord, the reply to the argument of my learned friend. And, Milord, on the last occasion, Milord, the argument which made by my learned friend, that was on the point of limitation. And I said it is barred by limitation because the proceeding which was taken before the arbitrator, Milord, that proceeding has not been, Milord, now can't be that provision of section 14 of the Arbitration Act cannot be waived. Yes. That there is a formal application required and leave is required either by filing a fresh suit or then, Milord, there should be leave by the court to make any addition.
Yes.
Then, Milord, on the point of, Milord, this order 1, rule 1, order 3, Milord. There, Milord, rule 1, order 3, the point was taken that the power of attorney was not submitted by the witness of the railway. Milord, here I had submitted, Milord, that the power of attorney is not required, Milord, in the government cases, and that authority is given by the Civil Procedure Code itself. And, Milord, then, Milord, Milord, the point was taken notice of production of document to the defendant, that certain documents which it was alleged that those lost, and then there was a police complaint, and then there's as a secondary evidence that documents were submitted before the commissioner of, Milord, the commissioner appointed to take Milord, the evidence. And, Milord, similarly, Milord, the documents which they allege the loss, Milord, the many documents of same documents, those were asked for production from the railway. And railway, my lord, also, my lord, due to the shifting of its office from Bilaspur, my lord, to some, my lord, from Raipur to the other place, my lord, many documents were original, were not traced. And therefore, the ask for production of those documents which could not be produced by the plaintiff, my lord. Therefore, the documents which they asked for production could not be produced, and the document which we asked for production was not produced, my lord. And those documents were the certain correspondences, my lord. Those are, many documents are admitted document. Then, my lord, the fourth point was taken.
Yes.
The fourth point was taken, agreement to the impossible act. It was stated that the contract work was impossible to act. My lord, here, my lord, it is submitted that there was hard rock, my lord, in executing the contract, and contract therefore could not be executed. My lord, here, my lord, the for this, my lord, and apart from that, they submitted that it was submitted that there was shortage of the Ultratech cement, there was the flood in the area at the site, and there was the law and order problem. So these were the impossibility of the execution of the works. And, my lord, in this respect, my lord, already, my lord, I submitted on the last occasion, my lord, that these are not the relevant ground, because the, my lord, special, my lord, conditions are mentioned that they have, my lord, it is already, my lord, provided in that. That is those things are already provided, my lord, in notes of argument dealing with issue number 3 and 4 as framed in the instant suit. My lord, I have filed my notes of argument where the issue 3 and 4 I have dealt with in detail. So these things I have dealt with in those 3 and 4. And, my lord, then, my lord, counter claim of the defendant number 2 and 3.
Yes.
My lord, it has been submitted on behalf of the plaintiffs that the defendant railway has only provided a chart claiming a sum of rupees 15 crores 30 lakhs and odd from the plaintiffs towards their counterclaim without providing the details of their claim. In this regard, the defendant number 2 and 3 submit that the being failed to perform the contract by the plaintiff of construction of bridge, the work was entrusted to another contractor. As a result, there was considerable delay in movement of passengers as well as goods train on the proposed third line. After termination of the contract, the defendant number 2 and 3 had issued fresh tender, and Messrs. CS Construction DKA, joint venture of construction of the said bridge, for construction of said bridge, by letter of acceptance dated 4/2/2016. The cost under the new contract was for the sum of rupees 22 crores 29 lakhs and odd, and the sum of rupees 9 crores 98 lakhs was cost more in construction of the said bridge. This is a difference amount. The defendant number 2 and 3 have claimed the difference of the said cost from the plaintiffs. Further, the defendant number 2 and 3 claimed loss of revenue due to the delay in operation of the third line to the extent of 3 crores 50 lakhs, because the third line could not be operative. And apart from this, this is also humbly submitted the cost of incomplete bridge that the plaintiff could not complete due to their negligence fault had been left abandoned till date, which is completely loss of the railway revenue and public money. The other particulars of the claim made by the defendant number 2 and 3 have been provided in paragraph 59 of the written statement cum counterclaim filed by the defendant number 2 and 3. Therefore, the said defendant railway submits that it is not correct that details of counterclaim was not provided provided by the defendants. My lord, now the judgments have been cited, my lord. There are 4 judgments cited, my lord. So one has been cited, my lord, 2024, 6th Supreme Court 130. And here this Manisha Mahendra Gala and others, appellant versus Salini Bhagwan, Avatar Mani and others, respondent. In this case, my lord, the judgment relates to the litigation of a private party, and this is not applicable in the case where railway is one of the party. Here, the power of attorney is said it's required. That is the rule 1 order 3, my lord, that if power of attorney is not there, then the person is not authorized to conduct the case. So here, my lord, the power has come by the statute itself. Therefore, this judgment is not applicable in the instant case. My lord, the second case which has been relied on, my lord, that is 1967 Supreme Court online SC10. Nehati Jute Mills Limited, petitioner versus Khaliram Jagannath, respondent. Well, these judgment had been cited on the proposition of impossibility of performance, where without any default of either party, the contractual obligation had become incapable of being performed. In the instant case, there was contract for supply of jute after importing from Pakistan, and for import from Pakistan is required import license. Due to the change of policy of government did not provide the import license to the buyers. Accordingly, contract was not performed. But in the instant case, it was not impossible to perform the work contract. The contention of the plaintiffs that due to the hard rock and under the ground well foundation method cannot be performed, while the fact remains that earlier bridge built nearby to the site was constructed on well foundation on the similar type of soil conditions prevailed. Then, my lord, in paragraph 12 of the judgment, it is stated that the said contract cannot be said to be or have been avoided, and that is, in any event, the stipulation as to obtaining the export license was absolute. Even that, then, my lord, it's not the license was not allowed, my lord. Even then, the contract was absolute, my lord. Then, third judgment which cited, my lord, AIR 2025 Supreme Court Civil 2505 Chodamma D by LR and another versus Venkatappe D by LLRs and another. Well, the proposition of the judgment relates to the issue when the defendant failed to substantiate the claim through the documentary evidence, and the silence of the defendant number 1 to depose is not a procedural lapse but a calculated withdrawal from the scrutiny of the fact, which is exclusive knowledge of the defendant refused to depose, reflect a conscious evasion from the evidential process. My lord, here it was alleged, my lord, that the one of the officers was in service and he didn't come, though it was calculated, my lord, approach to not to give evidence. My lord, it is submitted that by the plaintiff that one of the officers being known with the transaction in the instant case was in service during the time of recording evidence by this honorable court, and the defendant railway failed to depose the said authority who had knowledge of the transaction made in the instant case. If that authority failed to depose in that event, it will be treated as calculated withdrawal from the scrutiny of the evidence in the suit. This was the allegation. The defendant railway submits that even an officer who is known with the transaction of the suit is available, but due to his preoccupation cannot come to depose before this honorable court. Any other officer empowered under the said order comes circular can come and depose in the litigation after going through the entire records of the litigation. Then, my lord, the fourth judgment has been cited, that is the 2012 8cc 148. And, my lord, this is a lengthy judgment, my lord, and here the relevant paragraphs which I have dealt with, my lord, in paragraph 2 and 67 of the judgment. That is my reply.
Judgment.
That is the Union of India versus Ibrahim Uddin and others.
I had handed over a copy subsequently.
My lord. Here, my lord, paragraph 2 is that it is not applicable. This judgment will not apply here, my lord. That's why the
yes.
So, my lord, my lord, Are you having that copy? No, no, the judgment a copy. No, judgment right now I am not having, you know, that, you know, that, but I am relying on paragraph 2 and 67.
2 and
2 and 67. And my submission is this is not relevant in the instant case, looking at the facts of the case of this judgment.
yes.
My lord, now I will place, my lord, the oral evidence of Mr. Khuteta. You know, that is the
Evidence, sir. Now
We can see in rejoinder, he has to taken time only for the judgment.
you cannot go for the facts, only legal point.
My lord, why I am submitting, my lord, here, my lord, my learned friend taken the objection regarding the evidence of Mr. the deputy chief engineer, who is now deputy chief engineer, that he is not authorized, and his evidence cannot be taken. Documentary evidence cannot be taken. So on this point, my lord, there is, my lord, the oral evidence of this, my lord, witness, and in oral evidence, all the aspects have been covered. So that's why, my lord, I wanted to place.
Okay, no problem. You have taken the written notes of argument, no? You take all the things in the written notes of argument. You need not to again. Then he has to give the reply. It will never end it.
My lord, this is the only things, my lord, now remain, my lord, that the evidence of the of the defendant witness 1, that is, my lord, has taken on all the aspect of the case.
Correct.
And therefore the court can rely on this evidence of the, my lord, this so that evidence I wanted to place, my lord.
See, evidence is already there. Which portion you relied upon, already you argued the matter. Further, you want to rely upon, you put your written notes of argument, which question, which page number. And the court, when I will go to the judgment, then I will read that. No problem. But in reply, you cannot again go to the evidence.
So, my lord, in my
Permissible.
notes of argument, I one note of argument I had already submitted, my lord.
Correct.
Now after my learned friends, my lord, the argument, my lord, I have given the reply notes of argument, my lord.
Yes.
That is also I have prepared, my lord.
Correct.
But here I have not included my lord, this.
Not included once you file the written notes of argument in reply. You cannot allow, because once again you have allowed then reopening of the case. In the reply only, you have to give the reply with regard to the legal point.
My lord, here, my lord, only the evidence which has been laid by the defendant witness 1.
Correct.
Because on evidence, my learned friend attacked on evidence.
Correct.
Therefore, my lord, to counter that, my lord, I have placed this evidence. This covered my lord, each and every point of my lord, the contract. So therefore, these are becomes relevant, my lord, so that the case of the
Which point you are telling?
My lord, here, my lord, I have, my lord, my lord, Mr. Khuteta, my lord, has submitted, my lord, deposed, my lord, that it was. Have you been authorized by the defendant number 2 and 3 to depose in this case? Then the answer was that he has been authorized by the board letter order. So then, my lord,
Sir, this court, I am not on that. He is not a witness. He cannot give the evidence. That is not the question. The question which they have raised and which I have put to you, the witness who had appeared before this court, he has stated whatever the fact from the file. No problem at all.
Lord.
He has stated that he has no personal knowledge because he was not the witness to the incident. He was not present when the work was executed. Correct. he has also stated that he is not aware of the document. Only on the face of the document he has placed the document. The only question is that how far the evidence of the PW1 is to be considered as evidence of the plaintiff, because he was not the witness to the occurrence when the tender was awarded. He was not the witness when the work was executed. He not the witness when the work was cancelled. We not the witness when the bank guarantee was revoked. He being an executive engineer on the basis of the notification, yes, that I am telling that is appropriate, correct. It is the authority is having, even that notification is not there, the authority, any of the authority can and say, but the authority has to say, yes, this is the document signed by the party in my presence, I have knowledge. That's why I'm again telling, giving the evidence and proving the document are the two things. Giving the evidence, oral evidence, anybody can come. I can come after 10 years. I was in court number 32, 38. I had dealt with matter, this matter, this matter. But I cannot say, as I was the judge of sense of the court number 23, this matter was taken up for hearing. I cannot say that. When I was not held the court of 23. So that is the only, I am not telling that your PW1 is to be ignored. PW1 witness can be taken into consideration, but only the question that the document which you are relying upon, which the PW stated that it was not in his presence, he has no knowledge about the signature. So how you can say that document is proof?
Most of the documents are the admitted documents.
That admitted document, no problem.
Yes.
The admitted
And
documents.
certain correspondences
Correct.
that delay in execution.
Correct. And
Those,
second thing is that you have taken the plea. The officer was not in a position to appear because he has been transferred and he has been posted in other place.
only one officer was serving at that time.
Whatever it may
At the
be.
time of taking evidence, my lord.
Yes.
And
was present, but you have produced the and one chairman and something else, surveyor, whatever it is. He has also stated that the officer is still in the service.
only one.
No, both. He said both the officers.
Both or one, whatever.
Only one officer.
One or two, whatever it
and
may be. So what prompted the authority to come before this court to prove your case? What prompted your officer to come in court? You send as per the notification, you send the third person. That is the only case.
My lord, only those some letters, my lord, some letters.
Whatever, I don't.
for
I am.
execution,
I cannot say whether-
delay in execution of the contract. Those, the complaint that there is delay in execution, those were authored by that authority. And otherwise, most of the documents are admitted documents. And my lord,
I am not telling that. Admitted document need not to be proved. That is settled law. With regard to the document which was denied and you have not proved, how the PW1 evidence will be a benefit to you? That is the only question.
yes. And my lord, here, my lord, the soil, the survey report, that is admitted document. And there is a bar chart, and this mentioned itself that after this level there will be the hard coal available.
Okay, you give answer to me. You are reading out, or you give the specific answer to me. You are telling that the work is, as per the case of the plaintiff, the work could not have been it is not possible for the plaintiff to execute the work. That's why he has given the letter. It is to be foreclosed. Correct. It is foreclosed. Now you subsequently you have issued the tender. Twice the tender was issued. None has come for the execution of the said work. None has come for the execution of the said work. Then ultimately you have shifted the site to the second place. So how the court cannot rely upon the evidence of the plaintiff here? That is not executable. You give the answer to that. If your person, if in the tender issued by you and the third party has participated in the tender and the third party has executed the said tender, then the plaintiff would have been out from the court. Now, after the cancellation of the tender, foreclosure of the tender, you have published the same work for the remaining work another tender, but no one has come forward to participate in the in the said tender to execute the remaining work. Then you have shifted the place. So why?
Milord, here, Milord, the Milord contractor, Milord, they are not applying leftover work.
Correct. So not applying, and the shifted area it has been
Then,
applied.
Milord, there was a foundation, Milord, the well
See,
foundation and pile foundation.
Civil case, it is not the case is to be proved strict proof. In the civil case, preponderance of probability. Civil case is to be proved by preponderance of probability. And criminal case is to be strict proof. Here is the preponderance of probability. What is that? His case, since beginning, it is not possible to execute the work. Then he has surrendered that. You have accepted that. Then you have called the tender of the said work. Nobody has come. Subsequently, you have shifted the place of work. So what is your answer on that? How you can come out from that? Give answer to that. Reading all these things, no purpose should be served.
Milord, my answer is, Milord, that after, Milord, the cancellation of this contract, Milord, there was tender. And then the, Milord, the other contractor did not apply in that tender, Milord, due to it was a leftover work. Therefore, they did not apply. And then there was a delay.
Where is evidence? Only because of the leftover work, they are not. Where is the? That's why I'm telling. Show me what is the reason the other contractor in the second tender nobody has applied. You are telling that due to the work, leftover work. Show me leftover work. That's why it was not the other party has not applied for. Where is that? Where is the evidence you have brought?
Milord,
It is your case you have to
Milord,
prove.
here in this respect, only oral evidence is there. Oral evidence of Mr. Kuteta is there. Why this has been done?
Potato evidence cannot be. At that time, potato was not there. That's I am making you understand. At that point of time, potato was not the engineer, not posted at the site, at the said place of work. So that's why I'm again I have stated that you are not taken care of it. It is only the person, the deputy chief engineer or the other chief engineer who had issued the notice, who had issued the second tender. He could have been come to the court. Yes, because he has not done, this was uncompleted work. The other contractor were not able to do the work because of this. It is was the only patch of work was lying. That's why we have given the second place. We have shifted. That is not the case made out. Where show me the written statement. What is the written statement you made out this case? Because of this leftover work, that's why the has not come. If it is mentioned in the written statement, where is the proof? Where you prove that statement in the evidence? It is my bad habit. I am opening my mind in the open court.
Milord, in paragraph in page 14, and in page 13, the answering defendant also handed over the soil report to the plaintiffs on 27th August 2010. The plaintiff failed to perform the contract, and accordingly, the contract was terminated by the railway following all the procedure and condition of the general conditions of the contract. After termination of contract, all
Paragraph.
my lord, I am reading this page 13 of my written statement.
Paragraph.
And paragraph M,
Yes.
small m.
Yes.
The plaintiff failed to perform the contract. Accordingly, the contract was terminated by the railway following all the procedure and condition, general condition of contract. After termination of contract, all deposited money, including bank guarantee, are to be forfeited by the railway according to the general conditions of contract and other agreed terms and conditions. There is no due and payable by the railway to the plaintiffs. The contract was terminated by the railway due to non-performance and inability of the plaintiff to complete the work within the time framed by the railway, and the answering defendants thereby suffered huge financial loss on various accounts like loss due to delay in execution of project, more expenditure incurred due to performance of second contract with successive contractor, expenditure incurred for organizing second tender, pro rata expenditure related to railway personnel, expenditure due to organizing supervision, control of the project, loss of revenue due to less and late train movement, public harassment, and many other heads, including loss of expected income of revenue by goods carriers and like sources. The detail of such counterclaim of the railway are stated at the end of the written statement.
Yes. Stop here. Show me the evidence on this effect. Show me the evidence on this effect. Of your DW 1, 2, 3, whatever it means. Show with the evidence this statement is proved.
My lord, evidence is my lord, it is, my lord, the fact is this, my lord, the original.
Have you produced the second contract? Have you exhibited the second contract? Have you produced the second witness, the second contractor? Yes, I have been awarded. I have received this amount. How you prove this? Sir, very difficult. Pleading, very easy. That's why when I was that side, I used to tell the client, till the issues are framed, it is my duty. Once the witness starts over, it is your duty. Then the advocate nothing, but advocate only to see whether it is proved or not. So you have not produced the tender, second tender document before this court. Yes, this is the second tender, this amount. The first tender, this amount. This is the variation between two. The contractor has not come or your officer has not come. Yes, the first tender was 4 crore rupees. Out of the 4 crore, 3 crore was already given to the plaintiff. But the plaintiff has not completed the work. That work has gone lost, wasted. Subsequently, we have shifted. Again, 10 crore rupees was. There is that evidence for your contract claim. Yes. What is the next point?
My lord,
anything further?
No, my lord, the things the now is now whatever the my lord, my London friend submitted, I have replied to that, my lord. Now
I will take care of it. No problem.
Grateful, my lord.
No problem.
Grateful. Yes, my lord. My lord, may I submit my notes of argument?
May I also?
My lord, this is the my lord supplementary, my lord.
No problem. Counsel for the defendant concluded the argument and filed supplementary notes of argument. Let the same be kept with the record. CAV.
My notes are
Plaintiff and the plaintiff has also plaintiff has also filed. Plaintiff has also filed the composite written notes of argument. Let the same be kept with the record. CAV.
My lord, in my notes of argument, my lord, oral evidence of the defendant witness one, I have not dealt with, my lord.
I will take.
This is because of this reason I got it part heard sitting court number 41. Matter was part heard by lordship sitting court number 41.
for this reason, because ultimately my lord will remember everything at the end of the day.
And we have been able to finish.
Finish my lord.
My lord is kind enough that is completely hard today. My lord.
It is a duty. Once I have been accepted, then it is my duty to do that. Thank you.
Obliged. শেষ হলো 16টা ফাইল দেখেছেন এবার